Wait.
Can you hear us?
Yes, we can hear you. I think we just need Mr. Giuliani to turn on his camera.
Turn off
There we
my,
go. I see you now.
turn on my camera. Does it
Yeah.
turn off? I'm sorry.
No, you're good. I think we're all set then.
Okay, this is a continuation of the disciplinary hearing in the matter of Rudolph W. Giuliani, docket number 2020 D 253. I have a couple of administrative matters before we begin. First, we have a new court reporter, so I need to give the oath to her. Do you solemnly swear or affirm that you will faithfully and accurately report the present proceeding to the best of your ability?
I do.
Okay, one more administrative detail, and for the benefit of the respondents, the respondent and his attorneys. This is this proceeding is basically a bifurcated proceeding. We're in the liability phase right now, and at the end of the testimony at that phase, the committee meets to decide whether there's been showing of to make a probable whether or not there's reason to believe that a violation occurred. If we make that non-binding determination, the proceeding moves into the second phase, which is the sanctions phase, at which point disciplinary counsel can offer evidence in aggravation, and respondent can offer evidence in mitigation of sanction. I'm just mentioning that now because we will continue right into the sanctions phase after the committee meets to decide whether it's made a determination. If it makes the determination, we'll continue right with the sanctions phase. There will be no adjournment. So I just want to give you a heads up. If you've got evidence on sanction as a contingent matter, you should have it ready to go at the end of the liability phase. Is there anything we need to discuss before we begin?
Mr. Chair, I don't know if we're going to have actual, we're hoping that there'll be no sanction, obviously, but if there is a sanction, we would like to either have, besides oral argument on Mr. Giuliani's behalf on his past contributions to this country, et cetera, we would like also perhaps to have a witness or two, and I don't know if they could be ready right after this election, right after this hearing.
Well, that's why I'm saying now, if you're gonna have documentary evidence, you can put on evidence or not as you see fit. But what I'm saying is that it will have to be presented as part of this continuous hearing at the after the liability phase is complete.
The people who we're talking about are people. I don't know if they'll be available that particular minute.
Well,
The hearing's over. I don't even know when the hearing actually is going to be over. I can't.
There be some time to decide.
Yeah, can't we have maybe a day adjournment for these people?
well, I think somebody ought to get from your office working on it, and we'll that as if and when the need arises. Anything else?
Yes, if would character letters in lieu of testimony, maybe one or two instead of, because I can't guarantee, we don't know when this is exactly going to be over, and then
Could I I can't see you. Would there be a delay to decide it?
Yeah. No,
They're gonna decide like that?
they do, and it's a preliminary hearing. I'll talk to you later.
Oh, that's great.
Okay.
No consideration.
So I'm not seeing. Oh,
The microphone.
I see. I'm so used to talking into the other screen. I apologize. So there's no adjournment even to get someone to testify live.
Like I said, this hearing has been scheduled for a long time, and if there is an issue, we can discuss it at the time that the issue arises. I'm just giving you a heads up to avoid any problem to the extent that we can in terms of what evidence you might want to submit in the in any sanctions phase should it happen. I can't advise you on that. That's up to you.
All right, so, but letters are appropriate, is that correct?
Well, I can't, like I said, Mr. Leventhal, I can't give you an advisory opinion as to what's acceptable or not.
Okay.
I would, that's not my role, and it cannot be my role. I hope you understand that.
As soon as this part is concluded,
They make a preliminary.
you're gonna make a decision on the spot.
We make a preliminary, non-binding decision
No
As-
deliberation.
as to whether or not there has been a violation has been proved. It is preliminary, it is non-binding, but that's the process, and you can take a look at the rules and see how it's spelled out.
We would object to that, right?
All right.
Hope we preserve that.
Okay.
Mr. Fox, are you ready to go?
I am.
Okay, proceed.
Mr. Giuliani, we concluded yesterday in talking about some of the declarations that were part of Exhibit 36, which had been submitted by your lawyers. And I wanted to spend a moment on talking about the origins of those declarations, because I think
Well, just remind me again where we concluded yesterday, so I get the right paper in front of me. I think I remember.
I'm going to put the paper up and I'll refer you to the paper, but
Good.
we discussed, I think we concluded yesterday with discussing 4 declarations that had come out of Exhibit 36, which were documents submitted by your lawyers. And I think there was some discussion at the end about what those documents were. And so I want to focus on that briefly this morning. So the first thing I'd like to do is to refer you to Exhibit 33, Disciplinary Council Exhibit 33.
Which one is 33?
He's putting it up.
Oh, okay.
And if we'll go to, I think, the second page of that exhibit. Okay, can you make that a little larger? Now, you see, this is a letter that we wrote on the 27th of July in 2020 to your lawyers. And if you will go down to the first paragraph of the letter, you'll see that we refer there to some statements that you made in court or to the legislature or to the public, which were based on certain documents and videotapes. Then you see that.
Yes, I do.
And had you seen this letter before?
Oh, yes.
Okay. And then if you'll go down to the third paragraph of the letter, we refer to the 300 witnesses in the oral argument that you mentioned in the oral argument. And then we asked you to provide copies of all affidavits, declarations, or other detailed statements that provide the factual basis for your claims. You remember we asked for those?
I do.
Okay. And just to be clear, in this letter, and we can point it to you also, we also asked for some other stuff, some photographs and audio recordings, and 3 specific affidavits that you referred to in your Gettysburg proceedings.
Yes, sir.
And if you'll see the date on this, we asked that you provide this stuff by August 17. If you look, highlight that, please respond by August 17. See that?
Mhm.
Okay. If you'll look next at Exhibit 35, which is a letter from your, or transmission from your counsel. Yeah, if you highlight that portion, if you can, it's an email from Mr. Leventhal. And he indicates he's providing some photographs and so forth. And then if in the third paragraph, he says, we are planning on transmitting the statements, et cetera, to you by next Monday or Tuesday. You see that, sir?
I do.
Okay, and let's just get the date of this email, if we can. And you see, what's the date there?
I see August 23rd there at the top, Monday, August 23rd,
Okay,
2021, 10:41.
now let's go to Exhibit 36, which is the exhibit we looked at yesterday. This is the one that contained the declaration that we discussed yesterday. First, look at the date on this. Yeah, that's right, that focus. Look at the, can you read the date there?
The August 31, 2021 date.
Yeah, a Tuesday, okay?
Got it.
And then you'll see that and can you read the subject of the matter that was transmitted?
Christina Pesci shared the folder signed declarations with you, assuming that means John, right? And Barry, right? Okay.
Right. Okay. So Exhibit 36 purported to be the declarations that we had asked for in our letter of in July that supported the various statements that you had made to the court and also to the state legislature and to the public. Correct?
I'm sorry, is there a question?
Yeah, is that what you understood was being provided?
Yes, now that I look at it, that's what appears to have been provided. It's kind of a little different than that, but I tried to explain that at the beginning.
Okay.
In that group, there are. No, okay. It's a more mixed group than that.
May I interject, Mr. Fox? You and I had an agreement of a rolling admission. You and I had an agreement of a rolling admission.
Do you want me to clarify it or not? I mean, I'm happy to do it. Mr. Fox, would you like me to clarify it or not? It's okay.
Yeah, go ahead, clarify.
Well, I thought I said at the beginning, if I didn't say it clearly enough, that contained the affidavits that we had. Some of those I used in the allegations, as you can patently see. Some of them I didn't use. I can't say that I remember every single one of them. I'd say I remember the vast majority. I've been through them 3 times now. And I also know there were other affidavits that we haven't found that I relied on and oral statements that I relied on.
Okay.
So to paint it as on either side too extremely, in other words, these all support everything I said in the no, some were used, some were rejected. I remembered them all, no, most of them. And were there others? Yes, there were others that we can't find.
Okay.
I think that would be a better way to describe what that package is. And we have found a few others, not many. And as we found them, we'll send them to you.
Okay. And have you found any others that have contained direct evidence of election fraud in the Pennsylvania election?
Whatever we found, we sent you. I don't know. I'd have to go over what we sent you to tell you if we did or we didn't. We didn't send them to you. We didn't just send to you the ones that contained direct evidence. We sent to you what we had. We viewed your request as send us everything you have.
No, and you viewed it correctly, but let me ask you this. of these, you say you remember that some exhibits were missing, some declarations were missing.
Right, I'm thinking of one right now.
Okay. And these are declarations that do any of these missing declarations have direct evidence of election fraud in the 2020 Pennsylvania election?
I would say yes, but we might debate it. You know, it's circumstantial evidence. It depends on how you define direct evidence.
Well,
There's
evidence of particular
evidence from which you can make an argument that there was fraud. Yes, they do.
And was there any evidence, for example, that a particular identified voter voted who was not authorized to vote?
Well, yes, there are some in there, and I'd have to reserve that. It seemed to me, but this is just a vague recollection, that there were a few more such allegations than we supplied. If I may, just a quick explanation. The documents here were very helter-skelter. They were in a lot of different places. And when we finished in Washington, everybody went off in different places. And I had to reassemble these from other people. They weren't like all in my, they weren't all in my possession. Some of them were in my possession. Some were in Christina Bob's possession. Some of them were in Giuliani's possession. Maria Ryan. I tried to bring them all together.
Are you aware of any missing statements that demonstrate that a ballot was fraudulently cast in the 2020 presidential election in Pennsylvania?
Yes.
And can you tell us what those statements are that are missing?
I can tell you in a very general way. There's a statement. This might be more in the nature of a hearsay. There's one that I remember in the nature of a hearsay statement from a worker in another jurisdiction talking about her conversation with a worker in Allegheny County, in which they discussed their similar training. I think it's a worker in Detroit and a worker in Allegheny County. And we don't have that in either file. And I've been searching for it for three months. There are lesser, small affidavits or declarations that involve lesser numbers than that about what happened in Philadelphia over the 5 or 6 day period. They would be more in the nature of supplemental or duplicative, or in a trial, if I put them in, a judge might object that we're just repeating what we have already. But there are, just hold 1 second. Tried to recreate this last night. I kind of figured you'd ask this. Where did I put it? Oh, here it is. I went through the main affidavit that we gave you, meaning all of the declarations. And I wrote down where I thought there would be others. I can't say they add anything new, but they supplement what was there. For example, of the affidavits and declarations that we gave to you, there were a very, very large number on people that had alleged they already voted yet had come in to vote, alleged that they hadn't voted and had come in to vote, and then were confronted with the fact that they had already voted and denied it. And it turned out on the record they had already voted. It seemed to me there were a fairly equal number of no cure affidavits when I first put them together. And the number was very, very different. There was 55 of one and 26 of the other. And I once made a list that I can't find of what we had in each category. And that 26 was more like 40. So I don't know what happened to those. There were, oh God, I can't even read my own, I'm sorry. There are somewhere considerably more affidavits, although there were a lot anyway, of people alleging in different, almost all, not almost all, most of it pertains to Allegheny and to Philadelphia counties, a little bit to Delaware, of people who were shut out in various ways. But we had so many of those that there was a point at which I told probably Giuliani, I don't remember, who I said, put them in a separate file. We don't need any more of these. But they're somewhere. And they're in addition to the ones that were immediately available. I don't think it's of much moment because with 55 of them and the amounts of votes that they would represent, it's really just extra.
Let me just make sure I understand. You say that you had 55 statements from people who attempted to vote and were told that they had already voted by mail?
No, 55 poll watchers who were unable to see anything.
Oh,
And
55 poll watchers who were
about equally divided between Pittsburgh and Philadelphia. The number who said that there was the numbers who came in prepared to vote and denied that they had voted by mail was the number in the affidavits we gave you is approximately 36.
36, okay. And those 36 people had to vote provisionally because there was some indication that they had voted by mail. Is that what happened?
Right. They denied it.
Okay.
Vehemently. And they were in two different categories. Some apparently just didn't vote, I guess out of disgust or anger or whatever. No, I'm sorry. Some did vote and it registered. But 13, no, more than that. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. No, 13 of them, their provisional vote was never registered. They went back later to check, and they are not registered. Their vote was canceled for some reason. Their provisional vote was canceled for some reason.
Now, Mr. Giuliani, as you saw yesterday when we reviewed the transcript of the hearing before the Philadelphia Election Board after the election, people who vote, the election board makes a determination as to whether or not to count the provisional votes. With respect to those 13 people, did you go and see how the election board had handled their matters?
Some of the people working for me spoke to the election board and got explanations, but I can't tell you right now. I remember what the explanations were, and this was not. I mean, this wasn't the area that we were relying on the most. So we spent more time. We spent more time on the failure to be able to see any of the paper, because that was more, that was common to every single case that we had in the other 5 jurisdictions, where there were massive attempts to make sure that no Republican got to see a piece of paper.
Now, I think we've strayed a little bit from the question, so let's go back to the question that I asked you. And what I was asking you was whether there was any missing evidence, missing direct evidence that a ballot was fraudulently cast.
Yeah, I would say there is, but you know, but I'm saying that
Was there missing evidence that a ballot was cast by an illegal voter?
no, the only issue of illegal voter was from expert. No, I don't believe, I could be wrong, but I don't, because there's so many affidavits. If there is an affidavit about an illegal voter, it's one or two. There weren't like a large number like there are for these other categories of people identifying illegal voters. There was a estimate made based on the kind of analysis that you're allowed to do at this stage of, I don't know what you would call it, an estimate of the number of illegal voters that voted, and they vary with the expert. But those were not, but that would be considered in the realm of expert testimony, not direct or circumstantial, but it is allowed in election cases.
And these experts are whom?
These experts are people, but look, first of all they have available is the mail. So anytime, any of these expert analyses that you see is always a projection, because
Yeah, no, I'm just asking who they are.
the
Experts.
the experts that we employed or others did and made available to us.
Okay.
There were several others that were doing investigations, like the Thomas More Society. They weren't as active in Pennsylvania. They were very active in Michigan, but they would give us a great deal of their information.
Well, let's stick with Pennsylvania for the moment.
Well, they gave us information about Pennsylvania, just not as much.
Okay, and can you identify to us these experts?
I can by category.
No, I meant by name.
No, I'd have to go back and look and find out.
Yeah,
I mean, John Droz, who's going to testify, is one of them. A gentleman named Biggs. He did the one that, for some reason, as always happens when you read these complex reports, one of them seemed to me the most powerful to me, or maybe it's because I understood it. And that one I got to know better.
okay. Forgive me if I asked you this, but was there missing direct evidence? No, I did ask you that, so I withdraw the question. You're aware, are you not, Mr. Giuliani, that the Third Circuit said that in the complaint that you filed, specifically including the second amended complaint, you never alleged there were any ballots that were fraudulent or cast by an illegal voter?
I would, well, that could be so. I don't have a specific recollection of the estimate of illegal voters in Pennsylvania the way I do in Arizona and some other places. So maybe we didn't have an estimate of illegal voters in Philadelphia. I could have it confused with surely Arizona.
Arizona is not on my.
No, I know, but you have to understand when I'm trying to remember these things. I'm sorry, but my states overlap with each other.
Could we put up Disciplinary Council Exhibit 16, the Third Circuit opinion?
When you say illegal voters, you mean voters who aren't citizens?
Well, let me come back to that. Can we go to page 12, please?
Oh, voters who died. Yeah, sure. We have a lot of those.
And Can you make that a little larger? I can't read. Thank you.
Which case is this, Mr.
Third
Fox?
Circuit opinion. It's our exhibit 16.
On the appeal?
Yes.
Okay.
I'm sorry, I just can't read it. Can you find the portion that talks about, never alleged there was any ballot that was fraudulent? There we go. That's right, the paragraph there. The campaign never alleges that any ballot was fraudulent or cast by an illegal voter. It never alleges the defendant treated the Trump campaign or any of its voters worse than it treated the Biden campaign or its voters.
Well, that isn't right.
Okay, so the Third Circuit was wrong about that you did allege that.
Well, sure. I mean, just the non-cure cure would be an example of how we allege that the Trump campaign and the Trump was treated differently than the Biden campaign. Again, I'm a little confused as to if we're talking about the second amended complaint, we surely put it in there.
Ms. Giuliani, did you participate in the appeal?
Dead voters would be illegal. Dead voters would be illegal voters, and we had direct allegations of that, as well as expert testimony on dead voters.
Did you participate in the appeal to the Third Circuit?
Not much, no.
You didn't sign the pleadings or anything?
I don't know. I may have. I mean, I read quick. By that time I had moved on to other things because I realized we weren't going to win. So we had to try. We moved on to Michigan or Arizona. I was testifying in front of those legislatures. I'm just telling, the answer is yes, I signed it, but I gave it not the same kind of review. We're talking about the documents that I assumed that they were putting in everything that made sense, but I didn't have much hope that we were going to win.
And you were aware that the only issue that was raised in the Third Circuit was Judge Brand's denial of your motion to file the second amended complaint.
Yes.
I was aware. Now that I can't tell you I retained that, and now that you tell me, I'm refreshed.
And so when the Third Circuit said that you never alleged that any ballot was fraudulent or cast by an illegal voter, it was referring to the second amended complaint, correct?
If you say so. I didn't read it that carefully.
And that's the one that you signed, right?
That is the one that we signed, and I would take issue with that because I think that I'm not exactly sure how they are defining that, but voters who are required to vote because somebody has already voted for them, well, that would be a form of a fraudulent vote. And there were a lot of allegations of that, something like 35. So I don't know, maybe they're defining it differently.
Excuse me. The mayor was reading from the complaint. I'd like him to say which paragraph he was reading from.
No, I wasn't.
No?
What I was going to point out about the complaint is the complaint doesn't directly allege fraud. It alleges fraud as part of, there isn't a prayer for relief based on fraud. Fraud is part of a violation of due process or a violation of equal protection.
So let's go to the fraud as a violation of due process, which is where I was going to go next. Your argument for substantive due process was that because of the fraudulent nature of the vote, the voters were deprived of their fundamental right to vote, and that was a violation of substantive due process. Have I said that right?
You did, except you made it exclusive. That was one of the ways in which due process was denied. The changing nature of the rules, changing the rules in the middle of the game, changing the rules illegally, because that that right exists with the legislature, not with the executive, and that's pretty darn clear. That was also part of the, I mean, it all boiled down to those line of cases that say, if there are so many different irregularities, including fraud, in the way in which a state declares an election, the election's invalid. That was built up to that conclusion.
But for the federal law that is being violated, so sorry, the federal right that is being violated here is a right to substantive due process, correct?
Yes, sir. There, as far as I know, there's no federal fraud law that allows you to question or overturn an election based on fraud itself.
Okay.
It would have to be a violation of a federal right like due process, equal protection.
Okay.
And we used fraud, and that may be part of the problem with, is it defined with specificity? We didn't look at it as a fraud complaint. Why? Fraud complaint. Fraud was one of 3-4 pieces of evidence that would say an unfair election was conducted.
Now, you mentioned a moment ago an issue about changing the rules of the election as the legislature had determined they should be. Am I saying that right?
You are.
Okay. And that was what's the so-called election and electors clause argument that was in your complaint. Isn't that right?
It was there, but it was also in the
I'm sorry, we can't hear you, Mr. Giuliani. I maybe it's just me, I can't hear.
oh, I'm sorry. Can you hear me now?
Yes, yes, sir.
Uh,
You better start over because
yes. I think you would agree that sometimes due process in this context and equal protection overlap. The same facts that argue in favor of a due process violation will argue in favor of an equal protection violation. So, for example, if you cure some ballots, but not all, someone's going to make an equal protection argument about that, but they're also going to say you're conducting an unfair election. So it might sound in both.
Okay.
So here's an example. She changed at the very end the closing date for the ballots to come in, which I believe led one of the justices to say they had to be preserved because she was extending what Judge Alito had said. They had to all be in by the 5th. Then Bookvar changed it. We would argue that that is certainly a violation of due process. That would not be a fraud, but that would be a violation of due process. Since she did it for all ballots, you wouldn't say equal protection. But if it were applied unequally, you would then say it was a violation of equal protection as applied.
okay. But I was trying to focus a little bit on your election and electors clause arguments.
Okay.
Plain. And your argument essentially there was that the regulations that the Secretary of State or the interpretations the Secretary of State made of the Act 77 were not authorized by the legislature and therefore violated the election and electors clause of the Constitution, correct?
Yeah, I mean, that was a major theme of the entire argument in Pennsylvania, a little different than some of the other states, because there had been a massive legislative effort to do this. The legislature just expressed its will a year before, and here she was changing it. And as far as we could tell, we had a very legitimate argument that she was violating pretty settled constitutional law, that those changes have to be made by the legislature, that the legislature delegates this power, and it's very narrow. And when you're changing, basic rules, that has to go to the legislature.
But you abandoned that argument, did you not?
Well, I don't remember abandoning it. Maybe my people did on, tell me when we abandoned it. I don't remember abandoning that argument.
Didn't you tell Judge Brand at the oral argument that you weren't going forward on the elections clause claim?
No.
You have to remind me if I did. Don't we have one in the second amended complaint?
Yeah.
Could
Maybe I was referring to the fact that it wasn't in the. I mean, the difficulty, Mr. Fox, and I really would ask you to think about this. I really do believe when we talked, you understood this. The confusion is, I was defending a complaint that I didn't write and I didn't agree with. And it had truncated.
Which one?
The first amended complaint that was filed without my knowledge. It really was a reflection of the disagreement before I even got in the case between Mr. Hicks on the one hand and Linda Kearns on the other about which way to go, which happens with lawyers. I wasn't even in it long enough to be part of that or even to know it. Hicks and I worked, and he did most of the work. I contributed to the original complaint. That's the one I thought that Hicks was going to argue, and I was going to appear. And I was just going to add to that what I told you were the common allegations of law and fact, so that at some future point, we preserved the possibility of consolidating with other cases that we were beginning to see were almost 100, not 100%, 80% similar. They had a number of the main factors here, thousands and thousands of Republican inspectors excluded, votes that were counted where you get a chance to examine the paper, becoming important, not for picayune little things, but things like, was there fraudulent paper being introduced? And we proposed using the official paper and testing every piece of paper against that to determine if it's official paper. There's a process for doing that. And in every jurisdiction, we were refused. Never got a chance to do that.
Okay,
So my purpose was to make sure that if the day came when a federal court was going to sit there with 5 complaints and I or somebody else was going to argue these should be consolidated, the other side is going to say they're too different, and we want to be able to say, no, the main set of facts that we're going to adjudicate here are virtually the same, and it's much better, much faster to get to the court if we do it in one place. That was advice that was given to me by Kent Starr. It was given to me by other colleagues of mine in the Justice Department, Solicitor General's office, and people who had argued before the Supreme Court more often than I had. I had only argued once.
Mr. Giuliani, really, I'm focusing here on the election and electors clause claim that you had in your complaint. And isn't it a fact that the Third Circuit had come down with an opinion that said that campaigns had no standing to make those arguments, and therefore you didn't proceed on the argument in front of Judge Brand because of that Third Circuit ruling?
I don't know. I'm sorry. I don't understand the question, Mr.
All right, never mind. Let's move on.
Hold on. Are you asking if there's precedent in the Third Circuit? Marks v. Stimson, look at the district court opinion. I mean, this is a question of law. This is not a question of fact, Mr. Giuliani.
Gentlemen, Mr. Leventhal, Mr. Levin,
Yes.
Mr. Leventhal, if you have an objection, state your objection.
All right, I'm sorry. I apologize. Because
This is not the time for you to make legal arguments.
okay, I object. This is a legal conclusion. There is precedent in the Third Circuit. Look at the district court's opinion in Marks v. Stimson. There is standing. And I will argue standing at the conclusion of this hearing, and I reserve my ability to do so.
Overruled. That was not his question. Continue, Mr. Fox.
Let me move on to something else, Mr. Giuliani.
I am confused by it. I didn't think that was removed as a, I thought we were arguing right to the end, the electors clause. We certainly were in other jurisdictions.
Look, can we put up disciplinary council exhibit 8, please? You'll recognize this is the oral argument in front of Judge Brand. If you'll go to page 12, line 24 to 25.
Where do we have electors clause in? What paragraph?
Got to go start there and go over to the next page through line 4.
Yeah.
You recall
Line
that,
4?
yes. You saw that Judge Brand said that the Third Circuit opinion at the end of last week in the certain case, plaintiffs cannot assert standing in this circuit to raise their electors clause claims. You recall him saying that to you at the oral argument?
Now that I see it, I do, yeah. Mhm.
And then if you go down to lines 5 through 12, you'll see that you said you weren't going forward on it, but you were going to preserve the issue for appeal.
Yeah, well, that's what we did when, well, I don't know if I can't tell you the exact process that led us to inserting it in the second amended complaint, but we do make a claim there under the, I think it's count 3 of what I would call the real complaint, the one we were intending to proceed on. We make a claim under count 3 on the electors clause. And I don't remember the discussion about this. I know there was a discussion about it, pretty intense. And this was the way we made sure we preserved it.
Okay. Now, I was really, that's fine. We can take that down now. I wanted to turn now to the question of the remedies that you requested. We got into this a little bit yesterday with respect to the notice and cure equal protection argument. And as I understood what you said, it was that the remedy you were seeking was some pro rata reduction in the votes of both candidates based on the number of notice and cure votes have been cast. If I wasn't totally clear, but am I got that right?
No, I was a little confused that you found it so confusing because it's done rather often, and I think it's pretty straightforward. I found one provision that might make it simpler to understand. There's a provision in the Pennsylvania statutes talking about when you haven't vetted a military or absentee ballot correctly. And it's 25 PS section 31468 (G)(4). I'm just going to read it for the purpose of illustrating the remedy. And this is all over election law, all over the place. Further, only those ballots that have been verified under paragraph 3 shall be counted. So if there's a ballot that doesn't have the requisites listed in the opinion, you take that ballot and you don't count it. That is the remedy we were asking for. I didn't think it was confusing. It's done all the time. When a vote is that's what it means when you say a vote is, you're voiding a vote. A vote's invalid. You take the vote out of the number of votes in that jurisdiction. So theoretically, if 100 foreigners walk into an election district, they show no identification, they passed 100 votes, and you can all prove that they came from Antarctica, you would take 10 votes out of the vote in that jurisdiction. That's what we're asking for. And the remedy of, it's denominated many different ways in many different statutes: void, not counted. Some, like Wisconsin, go directly to take it out of the vote count. So then, if there were 1,000 votes cast and 100 were declared to be illegal votes under some theory, could be just technically illegal, then those votes would be deducted and there would only be 900 votes in that county.
Okay.
When if it's possible to deduct the exact vote, which is almost never possible because we do anonymous voting, you do that. When not, you take it out of the whole. You take it out of the entire vote.
And that's the pro rata reduction that you were talking about yesterday.
I don't know why'd you call it pro rata, but that's the reduction. It's if there are 13 votes in Philadelphia County that were cast by non-citizens, let's say, that I'm not saying there were, but example, then 13 votes would be deducted.
And how would you attribute those votes to decide whether to attribute those votes to Trump or to Biden?
Well, the same way you would if you took out 4 or 5 electors. It goes back to the smaller number. So now, if it happens in an even district, it has no meaning. If it happens in a district in which either candidate had a substantial lead, it inures to the benefit of the candidate who has the smaller number, which is why Republicans challenge Democrat districts and Democrats challenge Republican districts.
Okay. I'm not sure I follow.
That's 100 years of election.
Can you identify for me where in any of the complaints that you filed, you asked for that remedy?
We asked for the court to apply the remedy that was the most just, the most fair. We were going to argue remedy and the specific, and we also said whatever else the court might deem just and necessary. We weren't at the remedy stage. We were 2 days into the litigation and we were researching remedy, but we wanted to preserve whatever remedies were theoretically possible so that when we got to the remedy stage, the court would have available. We realized that that the court here would act as a court of equity in many ways. And we weren't going to really, most we were going to do if we got that far is recommend a remedy. The court was going to come up with a remedy. That was one among others. A new election would have been another remedy.
Okay, would you agree with me that you did ask for some remedy, specify some remedies that you asked for in your complaint?
I did, but I would also specify that we made it an example by saying whatever else the court deemed just and necessary, which is what you do commonly in a lawsuit. A lawsuit like this, even more so, because this is in many ways an unprecedented lawsuit, an unprecedented situation. We weren't smart enough to know all the remedies that would be fashioned here, nor do we think that our remedy, we thought of our remedies that we were suggesting as the beginning of a discussion if we ever got to that point. Let me put it that way.
Okay, so you didn't ask for this specific remedy, but it was included within the remedy of anything else that the court...
Ones we could think of. It's the ones we could think of at the time. What made sense, what seemed just,
Okay.
what fit into things that were done in other jurisdictions to remedy this, and what did the laws say? Like, I picked one statute, but there are many statutes in Pennsylvania over the years that talk about not counting votes. You don't count this vote, like this one. That have been verified under paragraph 3, only those verified shall be counted, which means the ones that aren't counted are taken out and the vote descends from 1,000 to 900. And you're left with whatever the consequences of that are.
All right.
That's not the sole remedy, but that's a remedy the courts have used.
One remedy you did ask for was, and I think you referred to it earlier, was prohibit the governor and the secretary of state from certifying the election results, correct?
Correct. We believe that under Article 2, Section 1, Clause 2 of the Constitution, we were at the stage where it should be given to the legislature under their plenary, this is Supreme Court language now, they have plenary power to regulate presidential elections, which the Supreme Court goes so far as to say that they can, any delegation they make, they can revoke at any time. And it's a controversial provision. It's been the subject of numerous law review articles. For some reason, over 100 years, it's never been fixed, although every young law student somewhere lectures the Supreme Court, they should fix this, but they haven't fixed it, and it's still there. So it was perfectly valid for us to rely rely on it. I thought we'd be negligent in our duty if we didn't.
Okay. And
I mean, I conceive of, and this is for purposes of why I don't think you should discipline me. I made the arguments that were in the light, I interpreted these in the light most favorable to my client, which is what I think you would want me to do, even if my client were a mass murderer.
And so you thought that you had alleged specific facts that would justify a temporary restraining order whereby the federal court would throw out 7 million votes from the citizens of Pennsylvania and direct the legislature to decide who got the electoral votes in the presidential election.
No, I didn't think we had alleged that. I thought we had begun the process of alleging that. I never think in my complaint that I've won my case. That would be like saying I brought a case for personal injury case, and based on my complaint, I expected that I get $2 million because my client is paralyzed. I expected we had begun the process of proving what was necessary to get to that point, maybe, as well as 5 other possibilities. I thought I had, let's put it this way, Mr. Fox, in the language of Rule 11, which I'm very familiar with, thought I had a reasonable basis for preserving that as a possible remedy, which is the way it really has to be looked at. If we ever looked at remedies as final conclusions by lawyers, half the lawyers in this country would have to be sanctioned because they always put in, and it's a joke, ridiculously large sums of money from which they negotiate down. And their justification for that is, well, I don't know how much is going to be involved. Let me ask for everything in the remedy section. Nor do I find any cases where a lawyer has been sanctioned because he made a mistake with the remedy that he suggested. You're so far from that in a case, it doesn't do any damage to anyone. I mean, I'm being sued by Dominion for I don't know, $20 billion. That's an absurd amount. Truly, believe me, it's an absurd amount.
But we're talking about,
They should be sanctioned for doing that.
you were asking for equitable relief, correct?
Yeah, which is even more in the nature of the court's discretion, as opposed to, they're not going to accept what I recommend. They're going to fashion it. Equitable relief is like a suggestion to the court of what they can do.
And you were asking for equitable relief on an expedited basis, correct?
But not immediately. I was expecting a hearing. No, I wasn't asking. The expedited basis was a temporary restraining order.
And
It wasn't an award of a new election.
and there are certain deadlines built into the election process whereby the results of the state have to be certified by a certain date, correct?
Correct, but yes,
I think
that can all be adjusted by the legislature. The real deadline is when the president gets sworn in. That's the real deadline. As you know, in Bush v. Gore, they went beyond all those deadlines. And because it was still in controversy.
And-
The deadlines are not in and of themselves completely unwaivable. They've been waived before in election contests.
And you were
If-
asking, you believed that you had sufficient evidence to justify a request for equitable remedy that would have prevented Pennsylvania from meeting that statutory deadline for when they had to certify the votes, which I think your lawyer said was November 23.
I don't think I thought of it that way. I thought of it as this is what needs to be done to find out, to flesh out these allegations, which appear to me to be true. I have no reason not to believe 250 affidavits. I mean, you can read the affidavits. I didn't make up the things that I alleged. I was standing in the place of other people who were making these complaints to me. What am I going to do? Tear them up and say, "Oh, gee, I don't believe that you didn't get to see 100,000 ballots, or that record that you have there of 100,000 ballots being counted, and you didn't get to see them. You made up." I mean, this is why I find this very, very strange. The whole proceeding, I based it on, I would say, more evidence than you normally have when you bring a complaint. I mean, the things that I alleged, even if I might have done a few inartfully, because it was done quickly, come from an affidavit, from a fact, from a person who told me that. I didn't make up the fact that they were put in pens. I've got 45 affidavits saying they were put in pens. I didn't make up the fact that there's no time in recorded human history that any political party did this to another political party. These are things that, as far as I knew, I could have been wrong, as far as I knew, were facts. And it's my obligation to plead these on behalf of my client. I did the best that I could to put them down in a way that was fair, but geared toward the interests of my client. And when I was asking for relief, I sure didn't expect to get the relief based on the complaint. I'd be really a poor lawyer. If I thought the judge was going to take my complaint and say, "Okay, we have a new election," then I would really be a jerk. I knew I had to prove what I said here. And I knew there was a long way to go and very little time to do it, because I did actually expect we were going to have hearings. I was very shocked when we didn't get a hearing.
Mr. Giuliani, let's go to the second amended complaint. You disavowed the first amended complaint, correct?
Pardon me?
You've disavowed the first amended complaint. You said you had nothing to do with it.
Oh, that one I had nothing to do with. Absolutely. Never saw it until it was filed.
Okay, and with the second amended complaint, I only want to look at allegations that were different from the initial complaint, okay?
Okay, why? I don't understand.
Well, because we've already talked about the initial
Oh,
complaint.
okay, all right, fair enough.
So that's disciplinary council exhibit 5, and 9. And can we look at page first? I actually remember 9. We start with the motion, and then we get to the complaint. But I want to get to the complaint, and let's go to page 14, which is paragraph 5 of the complaint. Here you indicate that there were 479 mail-in and absentee ballots in Allegheny and Philadelphia County, which were counted and as you say, not properly observed. And was it your contention that because they weren't properly observed, all of those 682,000 votes should have been discarded?
That would have been one of the arguments.
Okay.
We would have argued that those votes, which and these are the numbers that had been recorded by one or another of the inspectors in Philadelphia and Allegheny County. So these were votes that were counted without anyone other than the government official looking at the ballot. No one examined it to see if it really was a valid ballot, whether there was an address on it, whether there was on the outer envelope, whether there was a stamp, whether when it came in, when it went out. There was no examination as is required by law.
But wait a minute, Mr. Giuliani, there had been a ruling beforehand by the Pennsylvania Supreme Court that was not required by law.
Oh, no. They didn't have to look at the signature, but they had to look at the other identifying data.
Well,
There's no ruling that says they didn't have to look at the other identifying data on it to determine that it was, from an actual person.
okay, I'll withdraw that comment. Let me ask you this.
And in fact, you look when you see the affidavits, you'll see that a large part of the complaint is, we couldn't get to see anything on that ballot. We couldn't even determine in many cases. They report that they just ripped it apart and put it in, didn't look at anything.
But you don't have any evidence as to how many of these 682,000 ballots were improper. You just say that your people didn't have a chance to observe them, correct?
Which the law requires, and very, 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 very similar. If they weren't verified properly, they're not counted. The person might not have done anything wrong, but the person counting did something wrong, and therefore they're not counted. You go back to what I read to you about the military and other absentee ballots, and it says, only those ballots that have been verified under paragraph 3 shall be counted. It doesn't say only those ballots in which the voter cast an improper vote. The voter may have been perfectly justified in what they did. But in fact, we have rules. We have rules that have to be followed by the government, which make and can make a vote subject to not being counted.
But you don't know, Mr. Giuliani, whether the Pennsylvania election officials who looked at these mail-in ballots did their job properly or not.
Well, they didn't, because they denied that they're not allowed to do their job by themselves. They did not permit meaningful observation. And yes, we were going to preserve that argument for appeal because we thought that the ruling of the state Supreme Court of Pennsylvania was irrational on its face.
Okay. All right.
We thought that a ruling that said in a statute involving observation of ballots that you have to have all of the other parties present obviously meant in order to observe, not to sit around reading a book.
All right. So your position was that even though the highest court in Pennsylvania had ruled to the contrary, that the law required these observers to be closer to see how the election officials were examining these ballots, correct?
Mr. Fox, why do you say that in a way that's so unusual? Lawyers are challenging the constitutionality of the highest court of every state all the time when they think they have a good argument that it's unconstitutional. So I fail to see why you wouldn't think that at least it's arguable and rational to argue that a conclusion that where presence is required and presence is reduced to being a potted plant, you can't observe, you can't look, you can't check, you're put behind a pen, would be possibly declared unconstitutional, or that I had the right and obligation to preserve that argument for my client, in spite of the fact that a certain number of people may hate him.
All
Mr. Chair, can we break in 5 minutes? Would that be all right?
It's incomprehensible to me that would be considered an illegitimate argument.
Hold on. We break in 5 minutes, Mr. Chair?
We're gonna take a break at 10:30, the mid-morning break.
Okay.
So, Mr. Giuliani, I slated you that paragraph about the 680,000 voters because that was new in the second amended complaint. So I want to go to some other things that were new, and let's look at, and let's just take this as an example. Let's go to page 79 to 80, paragraphs 167, 168.
Oh,
Actually, just take 167. Let's
okay.
You start this paragraph by saying Democrats who control the defendant county election boards engaged in a deliberate scheme of intentional and purposeful discrimination to favor presidential candidate Joseph Biden over Donald J. Trump, and that by excluding Republican and Trump campaign observers from the canvassing of the mail ballots.
Yes, sir.
The language about Democrats doing this deliberately was new in the second amended complaint, correct?
I don't remember.
You don't recall that you added that to several?
I don't. I don't recall. I could have, sure.
But you will agree with me that the limitations on the observers apply to both the Democratic and the Republican observers.
Not in word, but not necessarily in practice. So it would be like, constitutional on its face and unconstitutional as applied. We have a number of incidents, and of course, only the ones we could gather that quickly, in which Republicans complained that Democrats were allowed to sit right next to the county official or city official that was counting, that they were in constant interchange with them, picking up ballots, at times didn't have masks on. We have a number of allegations that wasn't carried out as intended.
And those are included in those declarations that are part
They are, yeah.
Aside from adding this language,
Well, can I just add one other thing? And also, they had the inherent advantage that the people doing it were selected by the Democratic machine of the city of Philadelphia, which was the machine where the sheriff refused to enforce a court order. That's a pretty strong machine. So we didn't think we were in the hands of a neutral. We were under the illusion that the people who work for the city of Philadelphia, selected by the Democratic machine, are neutral observers.
okay. Now, you added this language in this second amended complaint about this being a deliberate scheme by the Democrats, but you didn't add any additional facts to support that, did you?
Well, I thought we were going to do that at the hearing, but we had witnesses to this. I had affidavits to this. I thought we were going to go to a hearing and we were going to present these witnesses.
Okay.
Who were going to say this. I had a rational, reasonable basis under Rule 11 to make this. I can show you the affidavits that say it.
All right.
I didn't make this up, Mr. Fox.
Okay. Would you agree with me that this was just a conclusory statement without supporting facts?
But I mean, this is a complaint. This isn't a motion for summary judgment. I'm laying out what we can responsibly allege. If I included all the affidavits, this would be a 2,000-page document. Normally, this is the way you do it. And then you have you put in a verified complaint because you're a lawyer and they take it based on your word. And then you go to a hearing. I've done 500 preliminary injunctions. I've almost never not had a hearing.
All right. But Mr. Giuliani, you understand that complaint is supposed to plead facts.
Well, that is a fact. It's a fact. It's a fact that doesn't have the supporting evidence listed there. But you don't put the supporting evidence in a complaint. The complaint would be 5,000 pages if you did that. Also, Mr. Fox, you're asking something of me that was physically impossible, given the amount of time that I had. I helped to prepare that with another gentleman in enough time to try to get it into court to save the case from the ridiculous amended complaint that was put in behind our back. I think under the circumstances, we did the best possible job we could do. And I really, doesn't do any good to be offended, but I'm shocked and offended that this is happening to me.
If you look at pages, let's see, where are we? Pages 89 through 90, paragraphs 196 and 197.
Oh, yeah, sure.
If you could just blow up 197 for the sake of illustration. Now, here's an example where you did plead facts in the complaint, right, Mr. Giuliani?
Yes, sir.
And these were facts that were not included in the first complaint. You recall that?
I don't recall that, but I'll take your word for it. It sounds like we wouldn't have had it by the time of the first complaint, right?
And these were facts about York County in which you claimed that the officials in that county handled the observers correctly, right?
Yes, sir.
All right. So, yeah.
I see it. Yeah.
Okay. So that was, now let's go now to page 97, paragraph 224. This is an additional fact that you pled in the second amended complaint that was not in the first complaint. Do you remember that?
Yeah, I mean, yes, I don't say that I can remember it, but it's obvious when I read it that this was put in the second complaint.
Okay. You recall that you were
Probably we didn't have this at the time of the first, but okay.
and it's an example of one observer who said he was denied access to the canvassing in Philadelphia, correct?
Yes, sir.
If we can go to page 99, please. And if we look at paragraph, well, let's. I'm sorry, I've got the wrong page reference here. I apologize. I meant page 110. I got the
110.
There's only scope to 89. I give you the whole thing.
I have 110. I think so.
and I want to look at paragraphs 269 through 271. They're fairly short. And you'll see that these concern a Mr. Mercer, who testified that when he was an observer in Philadelphia, he couldn't see adequately, correct?
Yeah, I see that. Huh? I remember his in particular. Yeah.
And this was a new fact that you pled in the second amended complaint, correct?
Yeah, that is one we could have pled in the first, but we had that from the very beginning. But I don't know why we didn't have it in the first, but we had it in the second. But as I said, the first I had less involvement with than the second, but you know.
And you pled this fact to support your count 7, which was a substantive due process argument arising out of the fact that these observers weren't close enough to see the actual ballot processing, correct?
Yes, I see that. I see that. Yeah, I did. That's one of the mean, I could have used it for some of the others too, but we used it for that, right?
The Pennsylvania Supreme Court looked at this identical affidavit, did it not, and determined that it proved that Mr. Mercer had been close enough to observe the election under the Pennsylvania law.
Well, I mean, I don't know how they could do that, except to say that this lawyer, who I believe, I may have him confused with the head of the Bar Association at one time, was lying.
Well, let's look at,
I mean, now there was a point at the very end, meaning in the last day of this 5 or 6 day counting period, when the election pretty much, when Biden had got ahead, when a number of the boards caved in and allowed some observation after 3 or 4 days of refusing to allow it.
let's
So I don't remember if Mercer benefited from that.
look at,
I see in the affidavits that some of them did, but by that point, the game was over.
let's look at Disciplinary Council Exhibit 20, please. You know, you'll recognize this is the opinion that the Pennsylvania Supreme Court entered after the election, in which it said that the social distancing rules were did not violate Pennsylvania law. You remember this opinion?
Of course I do. Yeah. Yes, I do. I do remember that opinion. This is the final opinion, the Supreme Court,
Yes.
and it was what, 5-2 opinion?
The one that came down on the day that you were arguing the case in front of Judge Brand. You remember that?
Oh, yeah. Okay. Sure. I mean, I think, yeah, I remember.
And let's go, I think, to the last page, which, I'm sorry, page 9, the last page of the majority opinion. And starting with the last paragraph in the first column. Are we on page 9? I don't think we're on page 9. That's 8. That's page 8. There we go. You'll see, and this goes on to the next page, that the Pennsylvania Supreme Court said that the affidavit from Mr. Mercer supported the fact that he had a meaningful opportunity to observe the election, the counting.
I don't remember Mercer saying he got to see anything. This, I mean, maybe we're quibbling over what meaningful way means.
Can we go on to the rest of that paragraph, which is in the next column?
It's a surprise to me that Mercer claims that he saw something. That's an interpretation of what's meaningful. He didn't get to see the significant facts that we would argue were critical. And obviously, we don't agree with this opinion. This is an opinion that we're going to preserve the right to argue was unconstitutional and incorrectly decided. I mean, there's no suggestion that when I included that in the complaint that I did something that wasn't based on at least a reasonable interpretation of what Mr. Mercer said. That should be the grounds for discipline, not that a court disagrees with me. Courts disagree with lawyers all the time. And I think I have the better of this argument about what constitutes presence. I simply don't think that presence means you sit there and you can't do anything. It would be absurd. And plus, how can my argument be in bad faith when judges agreed with me also? It's not as if I made up this argument and it's some crazy argument made up by an out of control advocate. Judge Cannon agreed with me. The dissenters agreed with me. So I have to make arguments that there's a basis for, not arguments that are necessarily always correct. If I'm stuck with that, I can't argue for a client. I think you're imposing a burden on me that's so totally unrealistic.
Let's
I'm
go
sorry.
back.
Excuse me, I withdraw that comment.
Let's go back to Exhibit 9, the Second Amendment complaint. And I want to go to the prayer for relief, which starts at page 122.
Yeah, I like to look at my own. It's actually easier for me to read the paper than it is that.
The one I really want to focus on is paragraph 327 on page 123. Now, do you recall that this prayer for relief was not in the First Amendment complaint?
I don't recall that, but I'm not disputing that it wasn't, but I don't. If you're asking me, do I have a present recollection of that? No.
And here, this is where you're asking the court to throw out all the ballots and let the legislature decide.
Let the who?
Legislature, General Assembly.
Yeah, that's what it says. Sure. It says because of all of the irregularities and illegalities and whatever in the election that we expect to prove. I'm not asking him to do it based on this document, sir, any more than if I sued for breach of contract for $1 million, I'm asking for the $1 million based on that document. I'm saying if I prove this and more, this is one of the things, notice the word alternatively, this is one of the things I suggest to you as a court of equity we could do.
Last thing I want to
They're not bound by this, they're not necessarily influenced by this. I fail to see how a prayer to relief to a court can be improper. What am I doing? Unfairly influencing them? They're going to make their own decision about whether, when we're finished with this whole thing, if it hadn't been aborted, whether that's a reasonable request or not. You can't take this in isolation now and say, oh, Giuliani asked for something that isn't supported by the facts that he had then. In almost every complaint filed in the United States, the prayer for relief is not supported by the complaint. You couldn't get relief based on the complaint. It's the beginning of a process. And you're making it appear as if it's the end of a process.
Giuliani, has there ever been a situation in the United States where a federal court has thrown out every single vote that was cast in a statewide election and directed the state legislature to determine who the candidate was or who the winner was?
First of all, your original statement is completely inaccurate. I'm not asking him to throw out every single vote. I'm asking him to throw out the votes that were illegally cast under the law of Pennsylvania or were unconstitutional, violated due process, violated equal protection. That's got to be a nexus to, so it was not all of the votes. It was more like, it was a lot of votes, but Trump was ahead by 800,000 and they had to make up a lot of votes. And there was just about uniform exclusion of Republicans from seeing a single piece of paper until the very end, which I thought was a very telling and damning piece of evidence. And it was organized and it was done in the same way. I'm talking about in Pennsylvania. I thought that was a very powerful case. I don't know if we've ever had a case like that. So you're asking me, okay, we asked for, as an alternative, we asked the court to consider, which is what you're doing in a prayer for relief. They're not bound by what I wrote there. Obviously, they're going to make their own judgment about it. And that's why I really do think you should withdraw your complaints about the prayer for relief, because the prayer for relief is not something that is based on what you can get at that time. It's what you hope to get in the future. And any lawyer is preserving the most possible you can get for your client. So you say to me, well, there isn't a precedent for this. I would argue there wasn't a precedent for this case. I don't know of a case in which Republicans were uniformly refused the opportunity to inspect absentee ballots. And I participated in it myself. I remember the Chads in Florida. There was a Republican on one side, a Democrat on the other, and they went, nope, nope, nope. Our Republicans were 50 feet back. They were given binoculars that didn't work. Some of them were pushed out. A court order twice was not followed. The sheriff said, I don't have to follow the court order. These were extraordinary circumstances we expected to prove. I didn't think I was going to get it based on the complaint. You know that.
Mr. Fox, I think this might be a time to take our morning break.
Thank you.
How much more do you have, Mr. Fox? Can I ask Mr. Fox how much more he has of Mr. Giuliani?
Well, it depends on whether I get answers or the same thing repeated over and over again. If we can get answers, I don't.
Unfair comment. I'm defending myself, Mr. Fox. Please.
Okay, Mr. Giuliani, just hold off a little bit.
I don't know. I really don't know. It depends.
Okay.
I think we'll be finished by the lunch break.
Defend myself.
Oh, sorry, I couldn't hear.
I think I'll be finished by the lunch break.
All right, thank you.
Thank you.
We'll take a 15-minute recess. We resume at 10:45.
Opening
Thank
up the
you very
breakout
much.
rooms now.
God, can we get a bridge? Okay, we got that. All right. Now, God hope this doesn't fuck it up. Let's see. We,
Yes, we're Mr. Leventhal, we're waiting for Mr. Giuliani to turn his camera on.
Okay, there it is.
Thank you.
Are we ready to resume?
Yes.
I'm ready.
Fox?
Just one other point about remedy, and I would like you to look at, we're still in Exhibit 9, but I want to go back to the motion that you filed for leave to file a second amended complaint. And I want to look at the sentence that begins at the bottom of page 8 and goes over to page 9.
is that exhibit 9?
Yes, Exhibit 9, page 8, paragraph 20. Right, and just to highlight the last sentence that begins at ultimately. Yeah, start up and you gotta go back to the last, that's right, there you go.
Share what he's doing. You see, go back there, you'll see it.
So, Mr. Giuliani, you announced in the motion for leave to file the second amended complaint, this is not a prayer for relief. The plaintiffs will ultimately plaintiffs will seek the remedy of Trump being declared the winner of the legal votes cast in Pennsylvania in the 2020 general election, and thus recipient of Pennsylvania's electors.
Well, I think what you've done, would you go back in that document? I think that's qualified by having to prove that. And I think I point that out earlier in the document. So could you
Sure, go back and let them
possibly put it in context?
Yeah, sure, absolutely. Can you read all of paragraph 20?
If you go back to the beginning, I saw it very, very quickly when you quickly went past it. I don't have it in front of me, so.
Can we go back to paragraph 20 on page 8?
Can we get a copy of this document, please?
Yeah, we got
Can we blow up paragraph 20 so Mr. Giuliani can see it?
Now, here, Mr. Fox, this is an early stage in a quickly moving thing. And I limited to, obviously, they're not going to give it to me unless I prove it. Here, after limited discovery through statistical analysis, plaintiffs intend to show, so we're going to need limited discovery, which we haven't had, that a substantial portion of the 1.5 million votes received by the defendant were counted in violation of Pennsylvania law. I say substantial portion because I don't know at this point what we're going to be able to prove, including the inclusion of Trump and Republican, the exclusion of Trump and Republican watchers from the canvass of mail ballots and approving mail ballots which are not comport with Pennsylvania's signature date and other requirements. Plaintiffs will also show that defendants' conduct was part of an improper scheme to favor Biden over Trump by counting improper votes in violation of the equal protection due process. Ultimately, plaintiffs will seek the remedy of Trump being declared the winner. We're not seeking it now. We're making a optimistic prediction of the outcome of our case. Now, am I the first lawyer to do that? I'm making it, and I'm not saying you got to do it now based on what I just showed you. I'm telling you, I got to prove all this, and you get to agree or disagree with it. Exactly what did I do wrong there, Mr. Fox, that other lawyers don't do?
Mr. Giuliani, I think if you could just limit yourself to answering the questions.
I know, Mr. Chairman, but it's really, never mind.
I understand, but as I said yesterday, you will have.
I know.
more than one
Again, I apologize. I'm sorry.
Okay, let's move on to something else. And I want to focus now on your oral argument on November 17th, 2020, before Judge Brand, which is Disciplinary Council's Exhibit 8.
This is where he brings up the million. You realize how tricky that was, what he just did. It was equally tricky.
Yeah, I'll show you these things if you need to see them, but you told us, I think, yesterday that you believed what happened in Pennsylvania was part of a nationwide conspiracy. And I think you said it occurred in, well, I think yesterday you said 6, but before Judge Brand, you said it occurred in at least 10 other jurisdictions, correct?
I did. By the time we get to now, I realized there are some that we weren't able to pursue. But I mean, at the time, that was the number I was given. But then we never pursued it, for example, in Nevada, because we would have had no chance of prevailing. It was a Democratic legislature. I mean, we changed our strategy and decided that the only way we were going to get our witnesses under oath so they'd be preserved for history is if we went to the state legislatures. And the only state legislatures where we would have had a chance of being accepted was state legislatures that had at least a Republican House or Senate. So that ruled out a few of the states that we originally, for example, just wouldn't have happened in Nevada. Both houses are Democrat, even though we had what my lawyers regarded as very substantial evidence of fraud. So eventually it came down to, by process of elimination, and that eliminated Minnesota as well. It came down to, I hope I get it right, Michigan, Philadelphia, Arizona, Georgia. Did I say, we did try Nevada, but then we abandoned it because we thought it was useless. And New Mexico also we thought was useless, but we did try. So the number changed over time. But it was essentially the same concept. We were asking the legislature to assert its power under Article 2, Section 1, Clause 2 of the Constitution, as well as the Supreme Court decisions. I've unfortunately forgotten the name of the 1892 decision, but it was reaffirmed in Bush v. Gore, which says quite clearly that state legislature has, they use the word plenary power to determine the electors and can withdraw any delegation at any time. And it would seem to me that if, in fact, our facts are provable and the election was affected by substantial, overwhelming irregularities and or fraud, that the state legislature had the obligation. Among other things, there's no question, and no one would disagree with this, that the number submitted to the federal government of votes is inaccurate. Whether Trump wins or loses, in each one of these states, it was demonstrably provable that the number sent in was totally inaccurate.
Okay,
Giuliani, I know that you have a lot to say, but honestly, I'd like to finish this hearing by Christmas, and I'm getting concerned that we won't be able to do it. Seriously, if I lost track of the question, if you could just kind of try to limit yourself to answering the question that's posed, then we can move on. Mr. Leventhal will be able to ask you on cross-examination, then you can put your case in and say whatever you want in response to his questions, but, you know, Mr. Fox is trying to get through it. And I think maybe you could try to help him move along.
I'll try, Mr. Chairman, but you failed to note that Mr. Fox asked me a question before in which he left out a paragraph right before that changed the entire meaning of what he asked me. So, I mean, I luckily noted that. So it's not, I'm not exactly being questioned. Well, never mind.
I'm just
I have to
asking you,
defend myself.
I'm just asking you to try your best.
I am trying, Mr. Chairman.
Thank you.
Mr. Giuliani, the only question I asked you was whether you had asserted in front of Judge Brand this nationwide conspiracy. But it is true, is it not, that even though you asserted it, you hadn't pled it, and you certainly offered no factual support for it.
No, you made it appear as if I was asking for that relief and didn't point out that in the paragraphs before that, I amended that by saying I had a lot to prove before I got there, which changed the meaning and the good faith basis on which I did that. And you're a really smart man, Mr. Fox.
Mr. Giuliani, we're talking about completely different things. I'm talking about your argument in front of Judge Brand now. I'm not talking about what you said in your motion in support of
That's
this.
correct. And I'm talking about how you asked a sneaky question. That's all. And I have to point that out to defend myself.
Your name is Fox, you have to live up to it, all right? Now, let's go back to the argument in front of Judge Brand. Would you agree with me that you had not pled a nationwide conspiracy and you offered no factual support for that?
No, I actually argued those facts in front of him. I didn't have the opportunity to plead it. But if you look at the argument, I think I began the argument with how this was going on in many, many districts. I think what you just said is a complete misstatement of what my argument was. My argument must have 2-3 pages talking about the national conspiracy that was going on, that this was unbelievably and unusually the same conduct at the same period of time. At midnight, they stopped the count when they weren't supposed to in 5 places.
I just asked you if you pled that. Did you plead it?
No, you asked me if I argued it or pleaded it. I'm answering the argued part, Mr. Fox. Would you please be fair in your questions?
You tried to.
I couldn't have pleaded it because I was arguing the first complaint, which of course didn't plead it.
All right, fine. That's all I want to establish. Let's go on. Let's look at page 15, lines 16 through 23. All right. Now, in this paragraph, you talk about the report of Jimmy Carter and James Baker. And you say in the last line, they very, very seriously warn us, quote, mail-in balloting is the largest source of voter fraud.
I don't see the quote. I'm sorry, Mr.
Just blow up the 21 through 23.
The one I have doesn't have a quote. Oh, I'm saying quote. Okay, I see. I see what you're saying. Yeah.
And that was in fact a misquote, was it not, Mr. Giuliani?
No, I don't believe it was.
Let's look at your exhibit, respondents exhibit 50.
It does have it.
Sorry, respondents exhibit 8 at page 54. This is the this is the report you're talking about, right?
Yes, sir.
All right.
I think it is. That doesn't look like it.
There you see. Can you see the names Jimmy Carter and?
Yeah. Hmm?
Okay. And let's go to page 54. And I want you, if, around 54.
Sorry, we had some technical difficulties, so I had to go back to the PDF. I apologize.
Okay, here we are. And if you'll highlight the first sentence under 5.2, which I think is the sentence Mr. Giuliani.
Potential. Are we on, back on the record?
We've always been on the record.
No, he said there was technical difficulties.
That she just having difficulty putting up the exhibit.
Oh.
So the actual quote was absentee ballots remain the largest source of potential voter fraud, correct?
Yes, I left the word potential out.
Yeah, that's kind of a big word to lead
No,
out.
it isn't. It isn't a big word.
Well,
It's the largest source of potential voter fraud, or it's the largest source of voter fraud. What's the larger one? What's the larger potential source of voter fraud?
Mr. Giuliani, you don't
No,
think,
really, never mind. This is really picking him.
you don't think there's a distinction between telling the court that a presidential commission said that mail-in balloting was the largest source of voter fraud instead of saying that it was the largest potential source of voter fraud?
No, I don't think there's a very big difference between the two. There is no other source of fraud that is larger, whether you describe it as potential or not.
Okay. Let's go back to, we're finished with that, and you may take a minute
Now I'm going to get disciplined. Stop.
to go back to Exhibit 8.
God almighty.
And now I want to go to page 16, lines 10 through 20. Now, this is your argument in front of Judge Brand, in which you cite election fraud that occurred in other cities and in other elections. Correct?
Yes, sir.
And you don't contend, do you, that election fraud in other jurisdictions, in other elections, is evidence that there was election fraud in Pennsylvania in 2020?
No, but remember, I was arguing, as I pointed out before, and you were disputing, I was arguing here that this was part of a national, not national in the sense of the entire country, but in anywhere from 5 to 9 specific Democratic sinecures, that this was a conspiracy that existed outside of Pennsylvania, of which Pennsylvania was a part. So here I am pointing out that there's a history of that.
And this conspiracy included Mayor Daley in 1960?
No, of course not. But I don't know if you know the RICO statute. The RICO statute goes back to prior history of 50, 60, 70 years.
Okay.
And so here I'm pointing out that this is not, I mean, a lot of people would look at election fraud and say, oh my God, that can't happen. A lot of good people would say that. And I understand that. I've dealt with election fraud and both as a candidate and as a prosecutor. But a lot of people don't believe it exists. So what I am pointing out here is, Judge, this is not so darn unusual. It happens. It happened a long time ago in a very important presidential election, or allegedly happened then. And it happened in 2018. And I happen to have specific knowledge of the 20-year history in Palm Beach County and Broward County, and exactly the percentage of vote that they used to determine whether they're going to fix the election or not. It was, if the election was within 2%, they would then try to make up ballots and bring them in. And they got caught in the DeSantis Scott election because they had a whole bunch of ballots up in Jacksonville that were headed to Palm Beach and Broward County. DeSantis fired the woman who'd been running it for 20 years. And since then, they've had elections that are flawless and get reported in 8 hours.
And your contention is that that was evidence that fraud had been committed in the Pennsylvania presidential election in
No, it's background to refute the general attitude that often happens. Oh, this is impossible. This doesn't happen. The New York Times writes editorials like that every week. There is no voter fraud. Republicans make it up, that sort of thing. It was to refute that, to put it in context.
Let's look next at page 17, lines 11 through 15. And here you're talking about voter fraud that occurred in Philadelphia in other elections, correct?
Yes, sir.
All right. And I will show them if you want, but I think there are other references to previous elections in which you say voter fraud occurred in Philadelphia, right?
Yes, I based that on newspaper articles.
Again, that's not evidence of any fraud that occurred in Pennsylvania in the 2020 presidential election, is it?
Well, it depends on how broad your trial is going to be. If you're going to bring in history and likelihood in a jurisdiction, yeah, you would argue that possibly is relevant. I've been able to get evidence like that of a historical pattern. Philadelphia would be a good example of that because you have so many articles about how it's replete with voter fraud. It isn't a criminal trial where you can't introduce, prior misbehavior. In a civil trial, you can. So, yeah, the fact that you happen to be in what some people would kind of colloquially describe as, a professional voter fraud city, Philadelphia and Chicago. I mean, the guy just got convicted a few weeks ago in Philadelphia of voter fraud. This is something, I don't know if you'd get it in. You might try to show this isn't just, they didn't just pick, Tucson, or they didn't just pick Omaha, Nebraska. They picked a place that has a long, long history of voter fraud that's been controlled by one political party for 50 years and has a reputation and then a bunch of convictions for corruption that kind of shocks the conscience.
Do you know, incidentally, Mr. Giuliani, how many election fraud investigations were conducted in Pennsylvania after the 2020 election?
After the 2020 election.
Yeah, the one we're talking about.
No, I was relying on newspaper articles. I thought I supplied them that lay out how frequent there are voter fraud investigations in Pennsylvania and how it's the situs of many after an election. I can't remember the dates of each one of them, but that was wasn't based on me. It was based on articles from newspapers.
All right, let's look at the evidence that you said you had that did relate to the 2020 election. And let's go to page 22 of your argument, lines 20 to 25. Now all right,
What line was it?
20 to 25. And you say here, among other things, one of the problems that we have in this case and why we had to amend it is because as compared to last week, we have twice as much evidence this week.
I'm sorry, is that a question?
Well, that is what you argue, correct?
It's kind of, I'm not sure I understand what I argued. I kind of need the paragraph before.
Oh, sure.
This is about the equal protection claim. Okay.
So would you agree with me here that you're arguing that you're getting increasing evidence all the time of fraud in the Pennsylvania 2020 election?
Well, I didn't say it now, maybe later. All I'm talking about is how I failed to see why this is a difficult equal protection claim when he was treated differently than the other candidate, which is kind of common equal protection argument. Now let's read this. Yeah, I'm talking about how we're going to get more evidence of denial of equal protection. We had more evidence then than we had when I originally argued. People were sending in. I mean, we had a system, a call-in system that was working 24 hours a day. And the reason that the documents involving this all show up at headquarters rather than in the various local lawyers' offices that's where the investigators were. And that's where they were processing the information and in some cases going out and investigating. And we were every day getting, I can't put a number on it, I'd just be guessing. Every day we'd be getting additional allegations. Here I'm talking about the ones having to do with equal protection, but they also related to being excluded from seeing ballots, whole manner of other things.
Okay, and that's what you represented to the court, correct?
Yeah, that we got more allegations, yes.
And now let's look at page 28, lines 16 through 20. And we've talked about this before. This is your representation to the court that you got 300 affidavits of declarations to support your allegations, correct?
That is correct.
And these are in evidence. Now, these should be withdrawn. These should be in evidence in this proceeding with all the.
Not, as I said, not all of them, but the ones that we could find, yes.
Okay.
And I have to qualify it a little bit. I can't be absolutely, well, it's both over-inclusive and under-inclusive. But how many did we supply? 245?
Yeah.
But there are more affidavits than that. And I can't be sure that every single one of them that we have in that was used in this litigation. This is what we found and handed over to you. Some of them I can remember specifically, some I can remember generally, and some I don't remember at all.
Now, the only exhibits that you actually offered at the oral argument before Judge Brand were 4 photographs. Is that correct?
Yes, I also offered to produce anything else that he wanted.
And the 4 photographs were designed to show these problems that.
Correct. It was designed to show that
May I finish the question, sir?
it was a football field, basically. We showed a picture of
Let
a.
me finish the question.
The 4 photographs were designed to show the difficulties that the observers had in seeing what was going on when the mail-in ballots are being counted, correct?
That is correct.
And aside from those photographs, you offered no other exhibits in front of Judge Brand.
Frankly, we didn't have the time to. But we offered to give him anything he wanted.
Now,
We expected we were going to have a hearing, and that's when we would produce these.
if you will look at, if we can go now to page 23 and 24, starting with line 24 on 23 and going over to the second line of page, I'm sorry. I've got this, let me see if I've got this. I have the wrong site.
Where?
No, I'm going to come back. I think I've got the site screwed up. I apologize. Well, let me do it this way. You took the position, did you not, in front of Judge Brand, that all mail-in ballots which were not inspected by observers were illegal?
The ones that I can't say in a universe of what I don't know that I took the positions that the ones that we had identified those were illegal. I imagine anyone not inspected would be illegal, but there may be some exception somewhere. The ones that we used as the general basis for our argument we took the position that they were void.
Let's go back to page 23, line 24, and then go over to page 24 through lines 1 to 2. That's what I meant to show you before.
What was the line?
Line 24 on 23, going over to line 2 on page 24. And again, if you need the context, I'll happily give it to you. But you argue here that the illegal ballots that were not inspected at all have been entered and counted. In fact, precisely 682,770 that we can count now. So your argument in front of Judge Brand was that these 672,000 ballots, the numbers slightly changed, but were all illegal, correct?
Yeah, but there's a certain category of ballot, which I think these are the ballots that were counted where the Republican inspectors were uniformly excluded, and they were able to make a calculation of how many ballots were counted that way. Some of them stayed there. You'll see one affidavit, 19 hours, 12 hours, 10 hours, 5. He puts it down in the affidavit. And some of them didn't make any prediction at all. But the ones who went to the trouble of counting the number counted in front of them, what they didn't get to see. I didn't do this myself, but I had my staff or my assistants, and that number kept changing. It kept going up. And I guess that was the number at the time.
Okay. And you didn't cite any authority in front of Judge Brand for the proposition that because the observers hadn't been able to see these ballots when they were inspected, that they were illegal, did you?
Well, I don't know this ever came up before.
Okay.
So there wouldn't be, I saw this in many, many ways as a case of first impression, and where the law says they have to be inspected and they're not. And in other circumstances, like under 25 Pennsylvania statute 3146A, where not every item is included, that the remedy is that they shouldn't be counted.
Okay.
So frankly, again, if you go to the Carter-Baker report, the critical element in preserving integrity when there is something that has more of a tendency for fraud, like mail-in ballots, is identification of the ballot at the time that it's being counted, because there's no other time that it can be verified. That's it.
The election workers are doing that, weren't they?
Yeah, but they weren't allowing it to be independently inspected, which is pretty much a uniform rule throughout the United States and Europe.
Right. Now, let's go now to page 26, lines 9 through 17. And here, I think you're arguing before Judge Brand that in the 7 counties that were the defendants, there were 1.5 million votes that were illegal.
I don't believe I am. I don't believe I don't believe I'm arguing that any are illegal.
I think we're at the wrong page.
Can I finish my, oh, no, never mind.
I think I gave you the wrong page. That's 27. I'm on page 26. Sorry. Lines 9 through 17. Those, I understand what you're saying here. Take a minute to read it, but I understand you're saying here, in the 7 counties, there are 1.5 million illegal votes.
Well, I think I'm saying that the only person that knows is an employee that we hadn't looked at all of those.
Well, 1.5 million votes that were entered illegally. That was your argument, was it not?
Yeah, if I did say that, I misspoke. I thought the context of it was clear, that the total that I had was 682, 770. We hadn't examined the rest of these yet. And I'm saying the only way we'll know is if we examine it. Is it potentially possible? I guess. But if I did suggest that it was 1.5 million, that is not what I was trying to say. I wouldn't be able to say at that point it was 1.5 million.
So how many illegal ballots were you contending there were?
Right at that point, 682, 770, right there.
And it was your position that all those ballots had to be canceled, wasn't it?
There might be some exceptions. I mean, there'd be defenses of some of it, maybe, but yeah, most of them, if the law says that a person has to be present from the other party to examine it. And if present means, I'm just giving you my logic. I don't have to if you don't want. Yes, my contention would be that if these weren't inspected by an independent person, they were useless. Under Pennsylvania law and under universal concepts of due process, because in almost every civilized country, they're inspected. Philadelphia would stand out, Pennsylvania would stand out as having elections that were more unfair than countries in which, they are definitely third world countries where they inspect absentee ballots, have an independent inspection of them.
And just to be clear, let's go to page 27, lines 14 through 18. And this is where you say that the ballots need to be canceled, right?
Oh, ultimately, always ultimately. I mean, not based on what I'm alleging here. This is a complaint. It predicts what you believe you can prove later. I don't get anything if I don't prove it. The judge knows that. I know that. So a complaint is a prediction. It's not a statement of what you definitely are going to get, what you're definitely going to prove. Gosh, if you had to do that, you'd have to be a mind reader.
And as I understand your testimony, it wasn't 1.5 million ballots that you were asking to be canceled. It was only 680,000.
It was the number that at that point I could determine was examined without inspection by a Republican inspector, as is done in almost all of the rest of the country and other democracies. I thought that would be a really good argument. I didn't know, and I think I could argue an interpretation of what I said there, that the 1.5 million is the total number that were counted in those counties, but I hadn't looked at those yet. So, I mean, remember, this is the beginning of a proceeding. It might turn out that those weren't, that those were perfectly fine.
Okay. All right. Now, in my review, and you can correct me if I'm wrong, and I'll show you the pages if you want me to. I saw that you argued 3 facts to support these claims. The first one was there was an observer in Philadelphia who had to use binoculars, and even those proved insufficient. You remember arguing that?
As one of many, Yeah, I did. I don't remember specifically arguing it in this case or some other case, but I did talk about the people who needed binoculars. It was more, they were given binoculars. They said, we can't see anything. And the government officials came over and gave them binoculars. And then they complained, we can't see it even with the binoculars. And I do remember a situation in which the real problem was that the people counting the ballots about 40 feet away, which you couldn't see anyway, had their back to the inspectors so that you could deliberately not see what they were doing. There's also testimony like that. But I did argue, as among many, many other arguments, that they were some, not all, in a few cases, they were offered binoculars. They were also offered monitors that didn't work.
Okay, I'm just trying to establish now the facts that you cited to Judge Brand at your argument on November 17.
Okay, well, that's one of them, I
All
think.
right. The second one that I think you cited to him was that when some of the people in Philadelphia tried to move closer, they were pushed back and they were not allowed to get closer. Do you remember that? I'll show it to you if you want to see it.
No, I do remember that, sure. Yeah, they were, some got closer and were pushed back. I do recall that, yes.
And when you made that argument, you pointed out, well, let's put up, let's go to page 26 and put up lines 18 to 24. You argued this happened to Democrats as well as Republicans, right?
Not uniformly, but it did happen to Democrats probably a good deal of the time. But there were exceptions in which Democrats were allowed to inspect and not Republicans.
And did you?
But I would say what I state there is more the rule than the exception.
Okay. Now, I've tried to go through your argument from Judge Brand, and I've tried to go through the initial complaint and the second amended complaint to pull out all the factual arguments that you made to support your position. Are there any other factual arguments that you made in those pleadings or to Judge Brand that we have overlooked?
If you give me a chance to read it, I would tell you what they are. I mean, I haven't.
Well, then I don't certainly want to delay the proceedings for that, but then if you will have an opportunity, as the chair has already pointed out, to testify later on. So perhaps if there are, you can let us know what those facts are. And I'd rather switch now to the
We're looking at it and tell you if there are other arguments.
If you pled any facts or made any arguments or cited any facts and any arguments in support of his position that we have not brought out. And if there are, I'd like to know what they are.
I don't know if I did or if I didn't, but I certainly alerted him to the situation.
Okay. Let's shift to the subject of the legal authority, and you'll be happy to know this is the second to the last area that I want to discuss. One of the cases I saw in front of Judge Brand that you argued two cases, Marks v. Stinson and Bush v. Gore. Was there any other legal authority that you cited to Judge Brand or that you relied on aside from Marks v. Stinson and Bush v. Gore?
I don't remember.
Marks v. Stinson was a 1994 Third Circuit case, correct? Third Circuit and District Court case, correct?
Yeah, it was. Yes, he was actually co-counsel in our case.
Mr.
well.
Marks. Mr. Marks was co-counsel.
Yes, sir.
All right. And that was a race for a state legislature position,
I
correct?
think it was the Senate.
Senate. And it was in a jurisdiction in which there were 40,000 votes cast, correct?
If you say so, then it was a small election. I don't remember the numbers.
And the margin of victory for Mr. Stinson was 420 votes, correct?
Sounds right. Very, very narrow.
And there, Mr. Marks had filed, before he filed a federal case, a state election contest, correct?
I don't remember that, but okay. All right.
And they had developed extensive facts. You recall that?
Yeah, it was a completed case. It was well beyond the complaint stage.
And there was a facts that showed that, and in those days, there was no such thing as universal mail-in voting, right?
No, you had to give usually a very strict reason and had to follow very strict procedures.
Okay. And Stinson's people had gone into certain neighborhoods and had solicited absentee ballot applications from voters, correct? There was evidence of this.
But you're reminding me of it, but yeah, that's right.
In fact, at one time, he paid his election workers a bounty for each one of the absentee ballot applications they could come up with.
I don't remember that, but okay. All right.
And instead of the ballots being sent to the voters, somebody in the election board actually gave them directly to the Stinson campaign, correct?
Again, if you say so.
Okay. And in front of the district court, and it was possible to, and the discovery identified the number of these fraudulently obtained ballots that had been given, correct?
I don't remember.
And you remember in front of the district court, there were 3 statistical experts, one of whom was hired by Mr. Stinson, all of whom agreed that the evidence showed that without the illegal votes, Marks would have won the election. You remember that?
I remember that was the showing. I don't remember the process by which they got to that conclusion.
Would you agree with me then that the facts of Marks v. Stinson were a far cry from the ones here?
Well, of course, we're at the complaint stage. They're at the completed stage, but we're hoping we can get there. And it's the principle of law that in which they required a new election that we're arguing for. There's no guarantee we're going to get there, but you often, there aren't many cases. First of all, this case was sui generis. You're not going to find authority for a case like this. I don't remember this happening in a presidential election. So how am I going to, I can't go make up cases, and I'm not going to do that. And so this was a case that showed that the court intervened, and there were a number of remedies that were suggested. Couple tried, and then I think the ultimate remedy was I think he sacked somebody first, and then the ultimate remedy turned out not to work for some reason. And then the judge ordered a new election, and Marks won. And strangely, the thing I remember about it most is the critical election, because it decided the majority leadership of the I believe it was the state senate. But we weren't trying to fool anybody that we're at that stage. We didn't cite it.
Okay.
That was at a different stage as ours, quite obviously, and we didn't pretend it wasn't.
Now, let's go to Bush v. Gore. You recall that the Supreme Court said in Bush v. Gore that the consideration it was given was limited to the present circumstances. Why don't we do this? Let's
Yeah, I remember that they used language there, trying to limit it so that it wouldn't be used too much. I mean, they, to the best they could, knowing that obviously whatever they do, they were trying to eliminate the presidential value of it. I do recall something like that. Yeah.
And Bush v. Gore arose in the context of a recount, correct? Not the original count of the election, but the recount.
That's correct.
And would you agree with me that there has been no case since Bush v. Gore where that case has been applied to overturn a statewide election?
I don't know. I don't think so, but I wasn't citing it for equal protection,
Okay,
for the doctrine of equal protection, and for the vitality of the observation and conclusion of the court 100 years earlier that the state legislature is the sole, primary, and plenary determinant of elections.
you know, you've alluded to that.
Which by the way, was a surprise to most state legislators. They didn't know that. I would have to, in order to convince them of that, I would have to show them the Constitution. They couldn't believe that our founding fathers had given them such authority. Maybe they don't think of themselves as, elevated as that, but the Constitution is clear as hell. The Constitutional Convention was clear, and even some of the writings of our framers made it clear that they wanted the body closest to the people if there would be a dispute of this kind.
Mr. Giuliani, you've alluded to this several times. It's called the independent state legislature theory, correct?
I don't know it as that. I know it as Article 2, Section 1, Clause 2 of the United States Constitution, which is plain as hell.
Article 2?
Yeah, it's in Article 1 has the election clause. Article 2 has the electors clause.
And do you recall that this was cited in a concurring opinion by Chief Justice Rehnquist?
I don't recall who cited it, but I recall it was cited, yes.
And the theory is actually going to be argued before the Supreme Court tomorrow, isn't it? In Moore v. Harper?
Yes, yeah, the more extended theory, yes.
Or extended theory, okay. But it's your contention that's established law now? What you just said?
Well, until they change it, I mean, that's what Rehnquist said. Am I going to disagree with him? And it's an interpretation, even if it wasn't established law, if it was one interpretation of the law, which it certainly was, and it was one that inured to the benefit of my client, wouldn't I be more or less duty bound to argue it?
All right. No, I'll leave it there. No, I do want to follow up with one thing. Getting away from Bush v. Gore, but do you remember in the Third Circuit that you did not challenge the dismissal of the complaint based on the electors and election clause?
I don't remember that. I didn't.
Okay.
I didn't handle the Third Circuit, and I don't know when that decision was made.
Okay.
Nor do I know the rationale for why we didn't.
To go back to Bush v. Gore. Bush v. Gore explicitly recognized, did it not, that local entities may develop different systems for the implementation of elections.
100%, yeah.
Okay.
And that's sort of the whole. Okay, yeah, yes.
All right. And in Bush v. Gore, the unusual circumstances was that a single entity, the state Supreme Court, was supervising the recount of the vote. Correct?
That's correct.
And the court had established no standards for what was going on was what's called generally undercounting the ballot, where it looked, undervoting the ballot, where it's not clear that somebody voted in the presidential election at all, right?
Yeah, I think that's right. You're getting a little beyond now my recollection of it, but
and you had all this stuff like the hanging chads. Do you count?
Can't forget those, right?
You all remember the hanging chads, right?
We'll never forget them.
Okay, and they looked to see if if there was an impression on the ballot,
And
which.
how far through did it go?
Right. And the problem was that the Supreme Court focused on was that the state Supreme Court had not given the people who were making these determinations any standards to apply in making those determinations, correct?
Yes, sir.
All right. And that was the violation of equal protection.
Yes.
Okay.
Excuse me, could I correct that?
No, sir.
That's not the right interpretation of the case.
Well, Mr.
Okay,
No, we'll fix it. We'll fix it.
we're talking about law now, not
Well,
testing.
you'll have your chance, Mr. Leventhal.
Okay.
All right. Aside from Marks v. Stinson and Bush v. Gore, was there any other authority on which you relied in support of your complaints or your oral argument before Judge Brand?
If there was, it's in the papers. If it isn't in the papers, then we couldn't find anything in the 7 or 8 hours that we had to do this. And I wasn't so surprised that we didn't, because it did seem to me to be a case of first impression, a case very unusual. I had never remembered something like this happening before. So in instructing my guys and women to look for cases, which I often do, I go back to things that happened in the past and say, well, let's look at this, let's look at that. I was having a hard time figuring out what we could look at. And I figured we'd come up with more as we were going along, but I thought this was going to get decided sort of based on the facts more than anything else, because they were pretty compelling.
Last thing I want to look at, and then we'll be done, is the answer you filed to the specification of charges in this matter, which is Disciplinary Counsel's Exhibit 4. You recognize this is the answer that you filed?
Yes, I do, sir. Yep.
If you look at page 9, you signed this personally, did you not?
I did.
That's your signature on page 9.
Yeah, that's my signature.
Let's go to page 8, and let's go to page 8, paragraph 45. It goes over to the next page, but stay on page 845. And can you make that, if you can blow that up a little bit, I would appreciate it. Now, Mr. Giuliani, in this answer, you said that because Judge Brand did not sanction you, that was an indication that he thought you had evidence of law and fact in support of the complaint, correct?
No, I didn't say that he approved of everything that I did.
All right, well, let's
What I said was, well, let me finish. What I said was, he didn't find reason under Rule 11 to sanction me. And if I had done something seriously wrong that would warrant disbarment, the first place you would look, although it's not conclusive, is the trial judge, particularly if he had reservations about what you did, but didn't invoke Rule 11. He obviously thought about it and didn't. He would be in the best position to do it rather than somebody writing a letter to a bar association in a different jurisdiction. Nor did any of my adversaries complain about it. So when you don't have complaints emerging from inside the case, that's not conclusive. I understand that. But it should suggest that maybe it isn't as bad as you're making it.
Now, Mr. Giuliani, you argued that under the 1983 amendment to Rule 11, Judge Brand would have been mandated to sanction you if he thought you had violated the rule, correct?
Well, I didn't argue that. I pointed out that gloss on it. I didn't argue that.
All right, strike that. You pointed out that he was mandated under the 1983 amendment to Rule 11 to sanction you if he thought you violated the rule. Right?
I cited that. I cited that, but I didn't argue it.
Okay, I'm saying cited. And in support of that, you cited a case called INVST Financial Group, which you said was a Sixth Circuit case from 2011, right?
I see that, yes.
Now, in point of fact, before I withdraw that, you also pointed out in this, did you not, that that opposing counsel had not filed a Rule 11 motion seeking sanctions against you, correct?
I think I did. I don't see it, but yeah, I think I did.
Okay,
I said they didn't complain.
all right. Now, in point of fact, the INVST Financial Group case was not a 2011 case. It was a 1983 case, wasn't it?
I don't know if it was incorrectly cited.
Could we put it up, please?
Pardon me?
We'll have to mark this for identification only. I mean, it's a case, it's not a evidence, but let's call it, what do we have it marked as? Yeah. Here's the case.
53.
53. Okay. Here's the case. We can go back if we need to show it's the same citation. 815 F second 391 that you cited. And you can see it was decided March 11, 1987. You see that?
I do. I see the date is, yeah. I got it.
Okay. So let's go back to Exhibit 4, page 8, paragraph 45. Again, can we make that a little larger? And you cited it as a 2011 case, correct?
Yeah, we put obviously we put the wrong date down.
Well, Rule 11 was amended in 1993, wasn't it?
Yeah, yes.
And after 1993, there was no longer a mandate that the court impose sanctions if the court decided there was a Rule 11 violation, correct?
I don't think I was aware of that.
Well, isn't it true, Mr. Giuliani?
Yes, I now know that it is true. Yes.
Okay, but so isn't it true that the quote that you used from this case, this that you said was a 2011 case, no longer applies? That Rule 11 has been changed since that time.
That's a mistake. I'm sorry.
Okay.
We made a mistake in that citation, both with the date, and that therefore creates the confusion and the misinterpretation.
Well, it's not just the date. It's the fact that you didn't consider the fact that you didn't consider the 1993 amendment to Rule 11, did you?
That's correct.
All right. So you would agree with me that we can't draw the significance that you drew from the fact that Judge Brand didn't sua sponte sanction you?
I would say it isn't as powerful. You can still draw a conclusion from it. I mean, there have been plenty of Rule 11 cases after that. Plenty of judges that have cited lawyers under Rule 11, and many, many cases in which adversaries cite you under Rule 11.
Let's come back to the adversary.
Excuse me, can I just finish? We made a mistake in that, but it's a mistake of degree. It is not as powerful an argument. You're right.
Well, so we'll come back to adversaries in a minute, but just focus on the judge. Are you aware of any statistics about how frequently since Rule 11 was amended in 1993? I want to keep that up if we can, because we're going to go to other portions of it. Are you aware of how frequently since 1993 withdrawn? Are you aware of any statistics that show how?
Objection. We're only concerned whether Judge Brand gave a Rule 11 sanction. And I'm throwing myself under the bus. I spoke to Mr. Fox about this. That's my mistake, this quote, and he knows it. And that's John Leventhal speaking.
I think there was no question yet posed, so why don't you pose your question, Mr. Fox?
Ms. Giuliani just said we could draw some significance from the fact that Judge Brand didn't sua sponte sanction him. And the question that I wanted to ask is whether he was aware of any statistics that showed since the 1993 amendments how frequently judges sua sponte sanctioned litigants.
Objection is irrelevant.
Overruled.
I am not aware.
Okay. Now let's come to the fact that the
I have myself argued Rule 11 cases and gotten sanctions. So I'm very aware of Rule 11. And in fact, the case that I argued is the reason for the amendment.
I see.
Demeroff against Abelson, which was decided in 78, 79, something like that.
that caused the 1993 amendment.
I guess it was an earlier amendment.
Now, let's come to the question of your opponents moving for sanctions. Are you aware that since Rule 11 has been amended, that there's a so-called safe harbor provision in it?
Vaguely.
Well, you
I
just,
haven't used it in 30 years.
I thought you just told us you were very familiar with Rule 11.
But yeah, but I was familiar with the genesis of Rule 11. But I haven't used it in 30 years.
Are you aware that before a lawyer can move for Rule 11 sanctions, he or she has to give their opponent 21 days to fix the problem?
Yeah, I am aware of that.
Okay.
Now that you say it, yeah.
All right. And you filed your complaint in this case on the 9th of November, 2020, correct?
That's right.
And it was dismissed by Judge Brand on November 21, correct?
That's right.
And the Third Circuit affirmed on November 27, correct?
Yes, sir.
So even if they had given you notice on the very first day that you filed the case, the 21 days wouldn't have run before the whole case had disappeared, correct?
But they wouldn't have known that on the day that they did it.
Okay. But it was not possible, was it, Mr. Giuliani, for your opponents to file for a Rule 11 sanctions against you because of the safe harbor provisions?
No, well, that because of the delay of the date of the timing.
Yes.
No, how did they know how long the case was going to go on? Could have gone on for a year.
Mr. Giuliani, you are aware that you can't file for sanctions until the 21 days have run. Are you not aware of that?
No, I'm aware of that, but they could have. I mean, very often when people do Rule 11, they raise it right at the moment of trial, and then they file it. But they wouldn't have known at that point if they had the 21 days or not.
Okay.
They made, in other words, no one during that argument made any objection, such as the objections that are being made now.
Okay.
And they were much more familiar with the case than any of the people arguing it from the outside. And plus the extenuating circumstances of this case, in that I was pushed into it at the very, very last minute and had to argue it.
Let's look at some of the other things in your answer. And I want to go now to page 3. And I want to look at paragraph 18, which unfortunately goes over to page 4. But the part I want to look at is on paragraph 18. And I want to specifically refer to your discussion of the case called In Re Canvass of Absentee and Mail-in Ballots. And you cite to this case at 241A3rd, 1058 in 2020, correct? You see that, Mr. Giuliani?
I do see that, yes.
And what you say there is that you were somehow vindicated because in this case, the court ruled that in the future,
I don't think I say I'm vindicated. I don't see where I say that.
let me just finish the sentence, and then you can tell me if I'm wrong. You're partially vindicated because the court subsequently ruled in the future that all the ballots had to be dated, right? That's what you said?
I don't agree with your characterization. I agree that I cited the case.
For the proposition that that in the future, if the ballots, mail-in ballots were not dated, they wouldn't be accepted.
Okay, I mean, that's what it says.
But that's not what the case says, is it? The case that you cited.
I don't recall that.
Let's look at Disciplinary Council Exhibit 21.
What's the site again, please?
Disciplinary Council Exhibit 21.
241,
21.
3rd, 1058. Go ahead.
This is the case that you cited, is it not?
Could I take a short break?
Tell Eston.
Mr. Chairman, may I take a short break?
We're gonna break for lunch in about 15 minutes, and if Mr. Cavins can sit in while you're out, that would be appropriate.
That's
it's
Mr.
the
Giuliani
mayor.
asking for the break.
But
Oh,
I
all right, I'm sorry.
I can be real quick and I can waive whatever you're doing right now.
No, don't
How
wait.
much more do you have on this, Mr. Fox?
I've got this issue, which I'm almost finished with, and one more.
Well,
Short break. I'll finish up shortly for lunch.
all right, it's noon. I was gonna go a little further. Why don't we take our lunch break now?
Thank
And
you,
we'll reconvene at 1:30.
Thank you.
Thank you. Okay, print me my exhibit 9.
Everyone now.
I hit something?
We can see you, if that helps.
But I can't see you. I have, oh, okay. It says the hearing will resume.
Yeah, I think they put us on the side until,
I got it.
You all came back early from the breakout room, so as soon as there's 6 seconds left, I take it down as soon as everyone's coming back from the room.
Everybody, we're waiting for Mr. Brozost, who was with us until about 20 seconds ago, and
He's here.
he's here.
oh, there he is. Okay.
I don't see me. Oh, yeah, I do. Okay.
Um,
Okay.
everybody's here, right? Okay. Let's go back on the record. I think, Mr. Fox, you're still questioning the witness.
Yeah, Ms. Giuliani, I'm going to withdraw my questions with respect to the In re Canvas case and talk about the McClinko case. So I want to go back to Disciplinary Council's Exhibit 4, page 3, paragraph 16. Now, you'll see in the second part of the paragraph, you discuss what you say is a Pennsylvania Supreme Court case called McClinko. I think I'm pronouncing that right. Which held that the statutes establishing that any qualified elector may vote by mail without having to demonstrate a valid reason for their absence from their polling place on election day violated, I think it should be, the state constitution's provisions that required electors to vote in person at their designated poll places on election day, since state constitution allowed requirements of all in-person voting to be waived only when an elector was absent for reasons of occupation, physical incapacity, religious observances, or election day duties. But statutes governing the no excuse mail-in voting system did not fall under any of the constitutionally enumerated exceptions to allow absentee voting, and a constitutional amendment to end requirement of in-person voting was a necessary prerequisite to establish a no excuse mail-in voting system. You agree that that's what that you said in your statement, that that's what the Pennsylvania Supreme Court held in McClinko?
I think it was an appellate court, but I think that's right.
Right. But it wasn't the Pennsylvania Supreme Court, was it?
It was an appellate court.
Right. And the Pennsylvania Supreme Court overruled that appellate court, didn't it?
Later.
Yes, later, the same year, correct?
Well, I don't know. Did they, before we wrote this?
Well, it's part of your exhibits. Let's look at your respondents exhibit 23. First of all, before we take that down, I'm sorry, could you? Well, that's all right. We'll come back to it.
What's the date of that?
I want you first, I just want you to note that McClinko is 270 A3rd 1243.
Yeah, that's in our exhibit 22. We put that site
I
on.
understand, sir. Now, can we look at exhibit 23? This is the Pennsylvania Supreme Court case, not the one that, not an intermediate court case. It's 279 A3rd 539. You see that?
Mm-hmm.
All right. And do you understand that that explicitly overruled the case on which which you cited in your answer?
Have the answer?
Yes.
Okay. And so if, just to be clear about that, if you look at
Have the answer?
Tommy?
I just want to look at the answer. Please give me a minute.
if you look at page 5,
Give the answer.
you're 23-5. that if you'll blow up the first paragraph on that page, or the full first paragraph.
Just a minute, we're looking for the answer.
Okay,
What's over here?
What paragraph is that, Mr. Fox?
what paragraph of what?
The answer that you're talking about.
Paragraph 16.
Thank you.
What's before? Yes, sir.
Okay, and you'll see in the last sentence that the court says before it now is a question of whether the General Assembly overstepped the bounds of this power and violated our Constitution when it enacted legislation that allows for universal mail-in voting. For the reasons that follow, we find no constitutional violation, and so we reverse the order of the Commonwealth Court.
Mhm.
Correct?
That's what it says.
And so the Pennsylvania Supreme Court, in the same year, after the case that you cited, reversed that opinion.
I'm asking you, was that done before or after we submitted these papers?
It was before.
I mean, obviously we missed it. I'm trying to figure out if it was extant at the time that we submitted this, or it happened after we submitted this, and we just didn't pick it up.
If you will look at can we go to the first page of the McClinko opinion?
When was it decided? I'm sorry.
August 2, 2022.
Well, I mean, I don't know if this is for sure, but it looks like this was submitted in July
Okay,
before
so-
this reversal.
all right, so you didn't learn, you didn't know it at the time, you couldn't have known it at the time you submitted your answer, is that right?
I'm just looking at the dates, Mr. Fox. At the time we wrote that, we did make a mistake in saying Supreme Court, but we couldn't have known that the Supreme Court was going to reverse it if they reversed it a month later.
Okay, but you never corrected your answer.
Well, I'm sorry, we didn't keep up on every single.
And you just make a mistake in saying this is a Supreme Court opinion,
Is that
correct?
really a necessary question? I mean, we didn't keep up with every single case that we cited and its history. I'm sorry.
Let the record reflect it's in our exhibit list. We weren't trying to hide it.
I apologize.
It's
for
in
not
our
keeping up with
exhibits.
Every single case.
All right, I have no other questions to this witness.
Good.
Mr. Leventhal?
Yes, thank you. Just give me 1/2 minute. Kindly go to DC Exhibit 17. And our exhibit. What is it, our exhibit? Both the same. Page 20. 20, go to their exhibit. We have the same exhibit. Is it up there?
Nothing up there. Want me to look at this? Okay, thank you.
Mr. Giuliani, I can't even see it. I'm gonna have to stand. Is that all right? Can you see me when I stand? No.
Well, the question is, can we hear you?
Standing by the screen so I could read the exhibit. Is that all right, Mr. Bernice? You can hear me though, right?
Yes, it is. We can hear you.
Okay.
Okay, so we're looking now at DC Council's exhibit 17, and it's our exhibit, what, John?
I believe it's 20, hold on.
I think it's our exhibit 20. Go to page 20, please.
I have,
Mr. Giuliani,
yes, sir.
could you throw that up a little more, John?
I can read it from here,
Okay,
Your Honor.
so when you read that, and the second, especially the second paragraph in, while the Pennsylvania Constitution mandates that elections be free and equal, does it not say that it leaves the task of effectuating the mandate to the legislature?
Yes, sir.
And are they talking about the notice and cure?
Could we not have not leading on these questions?
Well, you talked about it. I'm following up on what you said, and I'm going
I'll,
Object to the form of the question, leading.
I'll overrule the objection, but it may move us along a little more quickly at this point.
this has been
But I'm
going.
not gonna, that's not carte blanche, Mr. Leventhal. If you're pointing to an exhibit to have the witness, to direct the attention of the witness, I don't have a problem, but I may have a problem otherwise.
I apologize, and I stand corrected. Please look at the 1, 2, 3, 4, 5, 6, 7th line. What does that say?
7th line,
In quotes.
the first, down there,
In quotes.
it says, notice and opportunity to cure, procedure, notice and cure.
Okay. Could you continue to the next page?
Sure, it says notice and cure, notice and opportunity to cure procedure sought by petitioner. To the extent that a voter is at risk for having his or her ballot rejected due to minor errors made in contravention of those requirements, we agree that the decision to provide a notice and opportunity to cure procedure to alleviate that risk is one best suited for the legislature. We express disagreement, particularly in light of the open policy questions attendant to that decision, including what the precise contours of the procedure would be, how the concomitant burdens would be addressed, and how the procedure would impact the confidentiality and counting of ballots, all of which are best left to the legislative branch of Pennsylvania's government. Thus, for the reasons stated, the petitioner is not entitled to relief it seeks in count 3 of its petition.
Okay, could you go to the top, please?
What is that?
The very top.
The first page?
Yes. Who is the petitioner here?
The Pennsylvania Democratic Party is the petitioner.
All right, now,
Right.
who is opposing this notice of cure procedure?
It looks like the Secretary of the Commonwealth, Kathy Bachfar.
Thank you. Next. Please go to the second amended complaint.
Yeah, I got it.
No, we're gonna go on.
Oh, you're gonna go on this? Fine.
Page 60. DC number 9. Page 60, please. You highlight number 11. On 111. Can I look at the next page, please? Hold on.
Oh, I'm sorry.
Could you highlight number 112? Okay, could you keep it there, please? Okay, could you read those? And that's, what is this document?
This is my complaint. It's our complaint.
Which one?
Second,
Right,
the second.
okay, now,
Yeah, the second one. second amended
What are
complaint.
you alleging here?
We're alleging about, I think without reading it.
Well, read it.
Oh, it seems to me it's gonna be equal protection. Because it says right at the beginning, in addition, the disparate treatment between mail-in and in-person voters as to the verification of the voter's identity through signature verification has created an environment in Pennsylvania that encourages ballot fraud or tampering and prevents the Commonwealth and the county election boards from ensuring that the results of the November 3, 2020 general election are free, fair, and transparent. As a result of the manner in which the county election boards were directed to conduct the election, including the canvassing of mail-in ballots, the validity of Pennsylvania's votes who favor Trump have been unconstitutionally diluted through defendants' arbitrary, disparate, and/or uneven approval of all absentee and mail-in ballots,
And
without performing the requisite verification of the voter's signature, resulting in the treatment of by mail and in-person voters across the state in an unequal fashion, in violation of state and federal constitutional standards, in order to favor Biden.
And this is what Mr. Fox had termed a signature comparison, and the Supreme Court of Pennsylvania has approved the denial of a signature comparison to people who vote in absentee and mail-in. Is that correct?
That's correct.
Okay. Could you please go to Exhibit 28? Our Exhibit 28. All right, could you go up a little more so we see the site? All right, this is a 2022 case. Go up. The petition for writ of certiorari. Well, could you read that, Mr.
Sure. This is Ritter versus Migliori, and it's in the Supreme.
Just read the whole thing.
Oh, I'm sorry. You mean
Read what's in yellow.
the petition for a writ of certiorari is granted. The judgment is vacated. The case is remanded to the United States Court of Appeals for the Third Circuit with instructions to dismiss the case as moot.
All right, could you please go to, this is what,
28.
Go to 29, please. And I draw the panel's attention to this case also. This is, I'm not testifying, you could read the case itself. This was an application for a stay of the, not putting the date on. Mr. Giuliani, can you read this? This was denied, 3 judges dissented. Go ahead.
The Third Circuit held that the failure to count mail-in ballots that did not include the date on which they were filled out constituted a violation of this provision, but the Third Circuit made little effort to explain how its interpretation can be reconciled with the language of the statute.
Okay.
In my view, however, it appears that elements 2 and 5 are clearly not met.
Can you scroll down further? Okay. Can you read this now, Mr. Giuliani?
The problem with the Third Circuit's interpretation can be illustrated by considering what would happen if it were applied to a mail-in voting rule that is indisputably important, namely the requirement that a mail-in ballot be signed. Suppose a voter did not personally sign his or her ballot, but instead instructed another person to complete the ballot and sign it using the standard notation employed when a letter is signed for someone else, paren P. John or Jane Doe. Or suppose that a voter for some reason typed his or her name instead of signing it. Those violations would be material in determining whether a ballot should be counted, but they would not be material in determining whether such individual is qualified under state law to vote in each election, in such election. Therefore, under the Third Circuit's interpretation, a ballot signed by a third party and a ballot with a typed name rather than a signature would have to be counted. It seems most likely that this is what 52 USC section
Or that's
10,101A2B.
All right, fair, it's the Voting Rights Act, but Mr.
Rudolph, I thought I saw it, whose opinion is this that you're reading from?
Oh, go up, please. This is Alito and Gorsuch and Thomas, which is apparently adopted by the Supreme Court when they granted certiorari. Here, this was a motion for a stay. They denied the application for a stay before the election. After the election, they vacated the Third Circuit opinion and they, vacated the judgment and they granted certiorari. So basically, it was based on this,
I just wanted to clarify that the language that was just read was from a dissent.
it was the dissent, hold on, it was the dissent in the application for a stay before the election. Could you go back to the other exhibit, please? Now, the Supreme Court, after considering it, they granted certiorari. They denied certiorari before the election, and after the election, they granted certiorari, and they vacated the judgment, and the case was remanded to the United States Supreme Court with instruction to dismiss. The import of this, Mr. Chair, is that there were two dissents. Everyone else went along with the rationale basically espoused in the application pre-election. But post-election, they granted certiorari and they granted the petition and they for writ of certiorari and they vacated the judgment. That's the import of this.
May I object? This is argument. I think it's incorrect. It's a moot case, but this is better for.
Therefore, it's not a precedent, and therefore it's not a precedent.
Case now.
All right. So, Mr. Giuliani, reading Judge Alito and the Supreme Court decision, how does that comport with your argument? Could you describe to the panel?
Sure, I mean,
how is your argument about signature comparison?
this is a very unusual way to do it for the Supreme Court, but essentially they have removed the Third Circuit opinion that they originally didn't grant cert for. They did grant cert, they vacated it, and therefore removed it as a precedent in the Third Circuit. So it's no longer the guiding law until something changes in the Third Circuit. That's the way I would read that.
All right.
And I could be wrong, but that seems like it would have been. Who am I to, criticize the Supreme Court? There would have been clearer ways to do it, but that's an interesting law school exercise.
And could you go back to I think it's 20, the one before this. Yeah. Give me a second. Go ahead. No,
29.
29. Going up a little bit. We'll stop. Start from the down here, please. Okay. Do you see in-rate canvas of absentee and mail-in ballots of November 3, 2020? Could you go down?
Yeah, I do.
Go up. What does it say the Supreme Court did in that case?
The Supreme Court has held that the inclusion of the date on which the ballot was filled out is mandatory, and that undated ballots cannot be counted.
And that's how 3 justices of the Supreme Court interpreted that case?
That is correct. Was that a dissent at that point?
And did Mr. Fox take issue with your representation and your answer on that?
That we failed.
Yes or no?
I'm sorry. Yes, he did.
Okay. All right,
Want me to explain?
no.
Oh, okay.
Could we go to that case?
I'd like
I
to.
think that's Mr. Fox's,
I
that's
would
Mr. Fox's exhibit.
like to explain.
No, this case. November 3rd election. Give me a second.
What else?
Can I see the top? Okay. All right. Could we look at Judge Wentz? Concurrence, please?
So just to be clear, we're talking about the same case now.
No, we're talking about, could you go up, please, John? In-rate canvassing observation.
Yes, okay, all right, I got it.
2020. I think it's the same case, so let me make sure. Go up and see if there's Judge Wentz.
I think this is another one of those complicated. You need a scorecard.
Can you go to Judge Wentz, concurrence, please? I don't think this is the case. Give me a second, Your Honor.
We're back to Fizano Cannon.
This is not it, John. Let's see the exhibit list.
So much easier.
Hold on.
I like these better.
It's number 19. Hmm. 343rd, 591. That's fine. Their exhibit, DC exhibit 19. Did you go to Judge Wentz, concurrence? Go to Chris. Wentz. Yeah.
Page 28. That's what it says at the bottom of page 28. I can read it from here. Okay, I won't interfere.
Go up, John. I'm sorry, Mr. Chairman.
Look on my.
I'm gonna go in my airport. I'm tripping over wires here. Just give me 1 second.
Pennsylvania.
Pressing one. No, this is not, this is signature comparison. This is not it. Okay, sorry, Your Honor. I'll try 21. 21. Take full of wires, John. I got it. There, exhibit 21. My apologies. You open it? All right. There's Went. Yes. Yes, Went. Concurrence.
Perhaps you could move on to another topic and circle back to this after a break.
I'm here now, so can we, is this, could you go up a little more, John, so we can see? more?
Okay.
Okay. What was this case about?
We've got to get it back to the case now. Which case we're talking about?
This is, number 21, in-rate canvass of absentee and mail-in ballots of November 23rd. Of November 3rd, 2020. This is to do with, date and sign as a regularity.
Oh, well, the question was whether the ballot had to be dated and signed.
Right.
And
And what you put in your answer,
well,
Mr. Fox said that you.
We put it in an answer.
That in future elections,
and in future elections, it had to be dated and signed, and that is
how do you interpret that to be?
very simple. Very simple and very confusing decision. 4 judges ruled that in that particular case, it wouldn't be fair to require that the ballot be dated and signed, or to suffer the penalty of its being discounted. But then Judge Wecht, who had been in the majority in that case, switches over to the dissenters. So now it becomes 4-3 the other way, and says quite clearly here, I mean, if you don't have it underlined, that in the future, that will be required. So I think we cited it correctly by saying in the future, that is going to be a requirement. I remember this because we used a little chart to figure it out, which is what I do when you have Supreme Court decisions or decisions of courts where judges concur in part and dissent in part. It can become very confusing. But there's no doubt that Judge Wecht says that in the future, you're going to have to have the date, and it's going to have to be done properly in accordance with the statute. He says it's a very weighty matter. I'm relying on my recollection because I can't see that, but I think he says it's a very weighty matter.
Okay. And
You could easily miss it.
could you go to the answer, please, now of
My own answer?
no, I'm talking to our media guy.
What is it?
DCX 4, page 6.
Want me to read that?
No,
Which number?
I direct you to 32.
Can you see it?
The last sentence. You're repeating Democratic County versus Brookford, but read your last sentence.
Pennsylvania state
No, the
law
last sentence
of what?
of 32.
Give me a second.
Oh, the whole last sentence. Okay. Thus, respondent lacks sufficient information to form a belief to the allegation regarding Pennsylvania state law regarding the notice and cure procedure, except notes that Pennsylvania state law does not in any way prohibit the remedy request. Right? It doesn't prohibit it, and
So
it doesn't.
what do you mean? Wait for a question, sir.
Sorry.
What do you mean by that?
What I mean is there's no prohibition toward going ahead and requiring it or not doing it. And the equal protection argument arises from the application of it because it was applied in different ways in different parts of the state. And whether that's done as a matter of law or it's done as a matter of practice, either one can be a violation, as I think everyone knows, of equal protection, be as applied.
Was there a case that we went earlier that supports your view?
Well, sure. I mean, the case we just looked at. I mean, it supports our view. If you take out a little chart and you see the judge Wecht, well, never mind. We did that already. Okay.
Did you go to exhibit 38? Our exhibit 38. Giuliani.
Yes, Your Honor.
What is this exhibit?
Oh, this was a list, I think pretty early on, that was compiled. Could you go back to the title there? I'm trying to recall it. I know I saw this. I don't know that I used it much, but Montgomery County list of challenge ballots. This was given to me. But was not given to me with the group of documents that were given to me right before the argument by Bernie Carrick. It was a very important document given to me by Maria Ryan. And that was
What did Maria Ryan?
she gave me the Droz document, which is the one I kind of like the best.
When did she give you that?
She gave it to me during the day of the 16th. And I had a chance to read it quickly that day or night. And then I really absorbed it in the car going up to the argument. This I saw, but I don't think I used it.
You're not. Are you saying that it's absolutely true what's in here, or?
No, I have I should say I have no idea. It is what it is. That's what it says. And I'm not sure if I don't recall where and if I used this or one of my assistants used it.
But you had this as a.
I had this.
Let me ask the question, please.
I'm sorry.
But you had this as part of your challenge to the Montgomery County, which is one of the defendants in the lawsuit?
Yes, sir. Yeah.
I move this into evidence.
I have no objection.
Admitted.
Can we go to exhibit 39? Oh, no, he didn't object to this. I'm sorry. Exhibit 40. Could you scroll down a little bit? Mr. Chair, this is the redacted version.
Redacted.
All right. When did you receive this information?
I had it before the argument. It's hard to forget this. I had this before probably the day before.
And who
This one, I'm pretty certain was given to me by Bernie Carrick, along with one or two other documents.
And what was Bernie Carrick's role?
Chief investigator.
Let me finish my questions, Mr. Giuliani. Was your chief investigator in Pennsylvania?
No, and for the country. He
Please
was.
take your hand away from your
He was selected by President Trump to be our chief investigator, or I recommended him and President Trump agreed. I can't remember exactly how it happened, but he was our chief investigator for our legal team.
You're not swearing for the veracity of each of the
No.
exhibits, but are you?
No, I'm telling you, I know as much about the exhibit as what is on the exhibit. That's all.
But this is what your investigation team provided you with?
Yeah, and I at a rather early stage, because you should understand the only thing available at that point were the people who voted mail-in. this would not include any of the people that voted, I don't think, I'm pretty sure of this. This would not include any people who voted in the general election,
Why is that so?
because you don't get that list until much later. For some reason, you get the list of the people who voted mail-in and absentee right away as soon as they're finished. But this they don't put out in most states, and I think Pennsylvania is one of them, until March.
Okay,
So you wouldn't get this until, this is why a lot of the evidence, expert evidence, et cetera, is done by extrapolation and is allowed within certain limits by the court, because you're never going to have this in time to make an argument.
all right. Could you go to, would the same thing be true of exhibit, what exhibit is this one?
40. It's 40.
41, 42. Show them 41 of those, what it is first. 42. Keep going.
Yeah, there's well,
I didn't ask a question. 43. Would the same, if your testimony be the same as your testimony as to the prior exhibit that was put up on the screen?
yes, pretty much the same. I mean, it's all,
Was it also given to you by Bernie?
these three were given to me by Mr. Carrick, yes.
Okay, and are you swearing to the truth of these?
No, not the underlying truth.
Okay, but they were given to you and from your investigation team, is that correct?
Yes, sir.
I move these exhibits into evidence.
Mr. Chairman, I object, and I would like to forestall admitting these evidence until Mr. Carrick testifies. As we have made clear, we requested and supposedly received the information that was in Mr. Giuliani's files with respect to the election. This was not included in those documents. They were not, these four exhibits were not included in those documents. They were also not included in the documents that were originally marked as exhibits. As I understand it from the representation that was made to me, Mr. Carrick came and produced these documents after the original exhibits were submitted and marked. And accordingly, I think we should reserve on whether this should be admitted or not until Mr. Carrick testifies.
Are you subject to connection? So,
I'll reserve ruling on their admissibility at this point.
okay. And you stated you had Mr. Droz's report on the 16th. Is that correct?
Yes, I remember that clearly.
All right. Mr. Fox, are you reserving your same objection to Mr. Droz's report?
Well, my problem with Mr. Droz's report is this. I understood it to be an expert report, to be admitted for the truth of what it says. And I don't think Mr. Droz is an expert. And so I objected to it on that grounds. If it's simply admitted for the, well, so I do object to it if it's being offered that purpose.
But for the purpose of what Mr. Giuliani relied upon for his state of mind, you would admit that and subject to Mr. Droz's qualification as an expert?
It seems to me appropriate if Mr. Droz is going to testify to do the same thing and to withhold the ruling until he testifies and explains what it was.
That's why I asked you if your objection is the same. Okay.
And for the record, I have no idea what exhibit you're talking about. What number?
Oh, I'm sorry. What exhibit 11? It's our exhibit 11. I apologize. Mr. Fox and I have been talking so long about this case that he finishes
Okay.
like
Yeah, okay, as long as it's identified by number, that's okay. You may proceed.
okay. Mr. Giuliani, you had stated earlier that there might have been other documents that you didn't turn over that you had, but you had forgotten about. Was one of them the Montgomery County exhibit?
I'm pretty certain, yes. And I have a clearer recollection of this one, but
Now, Mr. Fox had turned over to us, I think it was in Discovery, the freeze memorandum. I don't think we included that in our exhibits. Was that another one that was given to Mr. Carrick that you had forgotten about? The freeze information?
well, I don't know that I had forgotten about it. I don't, it
Well, you didn't turn it over to,
it wasn't with my documents.
all right, you didn't turn it over to Mr. Fox. I think Mr. Fox,
Well, no, Mr. Fox is quite right. We didn't, there were certain documents, as I tried to explain earlier. The documents we turned over are the documents that I had. And I knew, and I tried to explain that they were under-inclusive and over-inclusive, but particularly under-inclusive. I knew I had other documents as well. I knew I had read other documents, but I didn't have them. I don't know where they ended up, but in some cases with Bernie, I think you might find the same thing with Christina Bob, and they held the documents instead of me. They didn't return all of them to me.
okay.
The draws one is the one that really gets me to remember the rest, because I really was impressed with the draws
Let me ask you a
number
question.
for
I'm
several
not seeking
for
to
several
intro-
reasons.
Excuse me, I'm not seeking to introduce this document
Which one?
right on the screen,
Oh, this one here.
right?
Do we have a number?
It's not on the screen. It's not an exhibit. I'm not seeking to introduce it,
Okay.
okay? Could you?
So it should be marked for identification if you're gonna, since you're showing it to the witness.
All right, I'll mark it for identification as respondents. A01, your, Mr. Chair.
What's the number?
What was the number? I couldn't hear.
Is it A or 1?
What's the next number?
The next number is 44.
No. All right, do I mark it as?
Mhm.
Okay, oh, I see, 44?
Yep.
Okay. I'll mark it as exhibit 44. But I'm not seeking to admit it because I know we didn't submit it. Is
Would
this
you-
one?
Would
Sorry,
you read the title of the document, please?
Sure. 2020 election information briefing, the Pennsylvania Republican Party by Seth Ketchel, MBA, November 11th, 2020. Could you could screen up a little bit and just show the, just give them a quick screening.
Well,
I'm not seeking to admit it.
well, we're publishing a document of an exhibit that has not been admitted.
I agree, because I didn't put it on our exhibit list.
It's not, Mr. Chairman, I object. It's not appropriate to publish a document that has not been even authenticated, much less admitted.
I agree, Mr. Leventhal, and notwithstanding the fact we can't read it, it's gone by so fast.
Okay, just put it on, just put the title page then, please. I listen when I'm told. Is this one of the other documents that you forgotten about?
Yeah, I don't think that's the right description. These are the documents that were not in my possession, which I do recall seeing before, when you asked me the question, before the argument. Some I relied on, some I didn't. So I don't know what that means, but that's about state of mind, but
Okay,
that's all I'll tell you. I could tell you more about this if you want.
on election day. Did Jeremy Mercer give you anything on that day?
It would be the day after the election. That's when I first met him. And it would be when I went to Philadelphia at the request of Corey Lewandowski and former Attorney General Bondi. And that's where I met Mr. Mercer. And I spent a great deal of time. You could call it interviewing him. You could call it talking to him. And he gave me other documents, but he gave me a document so that we could follow up on the witnesses. I recall that.
for one brief second, could you put that up and mark that as exhibit 45? And we're not seeking to introduce it because we didn't have it till later. This.
Oh,
Just put it up for a brief second because it lists names and everything. I just want to show it.
I'm not sure I understand what's going on here, but I object because I think,
You said that were there other information,
may I state my objection, please?
okay, you said there were other information,
May I state my objection, please?
sure,
I object because in effect, they are admitting these documents.
no?
May I please finish? He's offering these documents, I think, to prove the truth of the statement that there are additional things that Mr. Giuliani knew that he didn't include in his files. And while he's not putting the substance of the documents there, he's in effect offering the documents. And they're not on the witness list or the exhibit list.
I agree, the objection is sustained.
I can't mark it, Your Honor?
These
You
are
can
all,
mark it, but you can't show it to everybody.
Okay, no, I was only gonna show for an instant to show you that it existed, not that it wasn't a make-believe.
But that's the purpose of the whole exhibit. That's why you're offering the
You're saying
All right,
authentication?
Mr. Leventhal, I've sustained the objection. Please move on.
All right,
want me to describe
no.
them?
Or could you describe the information that he gave you? The information that he gave you?
Yes, he said, I'll do the best I can to, this is, some of substance from several years ago during a very confusing period of time. So this is not word for word. He was very upset. He explained to me what terrible situation he'd been put through. Seemed to me the day before and that day, he reiterated a lot of what Mr. Lewandowski and Pam Bondi had told me in the car over the phone when I was coming up, that he was shocked when he got there that they were all excluded and not allowed to see any documents. He said he was certain that they were just going to, there was nothing that was going to persuade them to allow any Republican to look at any piece of paper. He said as a result of that, he took his team. He had a large team. He himself is a lawyer. He either was the president of the Bar Association or an official of the Bar Association of Pennsylvania. Might have been head of his law firm for a while. Said he'd never been treated like this by the Democratic officials. And he said he had his people keep a record. And by his people, he meant, we didn't mean anything yet, of how many, he said, I thought the most valuable thing that I could do was I could have my people keep a record of the number of times they are entering a vote. And we're not getting to see the piece of paper that from time immemorial, we would always get to see, which it seemed to him was crucial to the legality of it. And he didn't understand why they weren't doing it. He showed it to me. I saw it myself. I mean, I saw them, I don't know, half a football field away from me, entering ballots. They had some people around them. They weren't by themselves, but there were no Republicans around them. I probably saw I was in a position where I could see about 7 or 8 of them. I was shocked. It looked like, I don't know what it looked like a prison or something.
Well, I just asked you what he gave you.
And then he handed me, at some point I said, we're going to have to get these witnesses and interview them. I spoke to, I had with me Dr. Ryan, I know for sure. I think I might have had Boris with me also, Boris Epstein. And I said, let's gather names. So we're going to have to interview these people quickly. I said, were all these people shut out? He said, every single one of them. He said, you can question them, but I don't think any one of them ever got to see a single piece of paper. And they are really upset and very suspicious that something very funny is going on here.
How many?
Well, then he handed me this list.
A list.
Yeah, he said,
Not in evidence, a list.
he handed me a list. And then he went and checked off, I guess this was his list of people. Now, this was his team. And then he checked off the people that would have knowledge of this. And he dealt with Boris and with Maria quite a bit on this. So the red marks on it are the people that we would, and you'll also see, which I don't understand what the big deal is about this. This corresponds to a lot of the affidavits we've already talked about.
Okay. Now, please go to exhibit 16, please.
Which is that? I'm
No.
sorry.
You look at the screen.
Our
16,
exhibit
our exhibit 16.
And this included the phone.
Excuse me,
I'm sorry,
it's not included. It's not in the
Oh,
minutes.
okay.
Put it down. All right, exhibit 16.
Hmm.
Could you go up a little bit? Stop right there. All right, I just for the panel, I just want to say this is the Judge Christine Pisano Cannon regarding the observation 6 feet. All right, go now to exhibit 17. So. Please go to the dissent. I'm sorry, stop right here. Just for the panel's edification, this is the reversal of Judge Cannon by the Supreme Court, saying that being in the room is enough. Please go to the dissent. I'll tell you which one. Go ahead.
Here.
No, keep going. Keep going. Stop. Can you go down a little more? Stop. Now go, I want to see the copy. Stop right there. Could you highlight this, please? Yeah, I'll take you. There, one way down. Could you read the dissent, please? One of the dissents.
This is Judge Saylor's or Judge Mundy's? I don't know which dissent. Well, I'll read it, whichever. You'll figure it out. The majority now vacates the Commonwealth Court's order and holds, while this language contemplates an opportunity to broadly observe the mechanics of the canvassing process, we note that these provisions do not set a minimum distance between authorized representatives and canvassing activities occurring while they remain in the room. Majority opinion op at 350. In so doing, the majority seemingly endorses what the Commonwealth Court did in its order, provide an opportunity to broadly observe. Appellee was merely requesting the ability to be able to observe the ballots in order to accurately relay compliance information. Appellee's brief at 22. Quote, the campaign simply wants the right to observe in a meaningful way that would allow the campaign to determine whether the board was following legal processing procedures, and if not, to challenge that process through appropriate litigation, end of quote. And parents.
All right.
The Commonwealth Court's order and the subsequent mutual agreement of the parties and the federal, to precisely that, and I would not disturb it accordingly. I dissent.
Earlier in the proceeding, not today, but
May I take a
no.
recess? I have to take a
Oh, he wants a bathroom.
for the
break.
same reason you do.
Hold on. Can we take a break, Your Honor, for two minutes?
All right,
We're almost finished. We are almost finished.
okay, we'll take a 5-minute recess.
Excuse me, I'm sorry.
Thank you.
I will open up the breakout rooms for everyone.
Okay. Everybody's back. Mr. Leventhal, you may continue. Mr. Leventhal, if you're talking, I can't hear you.
You guys are on mute. There we go.
I'm sorry.
How are we now?
Okay, now.
Okay.
Okay, all right. So, Mr. Giuliani, Mr. Fox read you a portion of Exhibit 17, which is the Supreme Court's reversal of Judge Cannon, saying that 6 feet, you had to be within 6 feet, saying that Mr. Mercer testified that he was in the room. Could you describe the room that where they put the observers in Philadelphia?
I can describe it. Yeah, sure. It was, well, he describes it as 2 football fields. Others would describe it as 3 football fields. I would describe it as a gigantic auditorium. From my own, I was in it, remember, a gigantic auditorium. I think maybe they watched basketball games there and hockey games. I don't know. I'm not sure which one it was, but it was not a room. It was a convention hall. And they were spread out.
Gotta talk loud.
And they were spread out at all different parts of the convention hall. So the closest observer would be 20 to 30 feet, and the furthest 2 football fields away.
And you heard earlier. Only one more area, Your Honor, and I'm finished. Mr. Giuliani, Mr. Fox had stated to you the second amended complaint. Is there any cause of action stating fraud in there?
You mean as a claim for relief? I don't believe so, no.
In any of the counts, the heading of any of the counts?
No, no, the answer is no.
And you added more counts in the second amended complaint than in the first amended complaint?
Yeah, but
Yes or no?
yes, yes.
And were those counts sounding in due process and equal protection? Yes or no?
Yes, and also elector and election clause.
Okay. I have no further question.
Mr. Fox?
No questions.
Mr. Giuliani, I do have a few questions to clarify some things in my own mind, if you don't mind.
I don't.
First, the chronology, as I understand it, on election day or around election day, you were asked by the former president to take charge of his litigation, post-election litigation matters. Is that right?
Yes, sir. I was told to take.
Yes or no?
The answer is yes, but I was told to take charge of the campaign. I interpreted it as the litigation part.
So you were at that point, you understood you were acting as an attorney for whom? Who was your client?
I regarded it as, and then we put out a press release, which I guess states it. I was at the time, I was already his personal attorney. I had been for two years. And I was adding to that being attorney for the Donald Trump campaign in the capacity of overseeing whatever election litigation was necessary.
So you were the lawyer who was the general commander of this litigation process for the Trump campaign?
I'd say that's a fair interpretation, yes.
And that was I think you said it was a nationwide litigation strategy.
Yeah, I didn't know that immediately, but as soon as I got over to the campaign headquarters and they came in and started briefing me and put up the whiteboards all over the country, I realized probably didn't know what I was getting into when I first said yes, but yeah.
And by nationwide, I don't mean all 50 states plus DC, that there were some states that were around the country.
Yeah, I think at that point it was what Mr. Fox said, about 10 or 11 states were in question at that point, maybe 12.
And you had, as I recall, you had essentially a war room in Arlington, Virginia.
Yeah, the Trump for President campaign headquarters were in Arlington, Virginia. And there was one very expandable conference room. And that turned out to be our main place to work because everybody was working together and singular offices didn't really matter as much.
And by our, you mean the legal team that you had assembled?
The legal team I assembled and whatever was there that joined with us.
Okay, and there were also lawyers in each of individual states that you worked with, who you relied on as local counsel, essentially, right?
Sure, there were a lot more of them, yeah, and some had already. I'm sorry. Yes.
Sorry, and in Pennsylvania, I think you said there was a lawyer named Hicks with whom you worked.
Yes, sir. He was the principal lawyer in Philadelphia.
Mr. Chair, excuse me for a second. I'm not going to stop you from answering any questions. Of course I can. But we will bring all this out when Mr. Giuliani testifies on our case in direct, if that'll be helpful. But it's up to you.
I'm not going to go through the entire, I'm just trying to orient things because as you might understand, I'm not familiar with what happened here. So had you ever worked with Mr. Hicks before?
No, I didn't know. I don't believe I knew Mr. Hicks. I might have met him. I meet a lot of people, but I have no recollection of working with Mr. Hicks.
But he was, and I assume he had other lawyers working with him at the time?
He did. He had a staff. I don't know. Yes, he had a staff working with him and had already handled some matters for the campaign preceding me.
And as I recall, essentially, Mr. Hicks took the lead in drafting the initial federal court complaint that was filed. Is that correct?
That is correct. Yes, sir.
But before it was filed, you met with him and you reviewed it, and I think you said you added some material to the initial complaint. Is that right?
Yes, sir.
And that was because you, again, I understood it, you expected that this lawsuit would become part of I guess you'd say, a multi-district litigation.
That was our hope. We certainly wanted to leave that option open.
So what was it that you added to the draft of the Hicks draft of the complaint that you felt was important to make it compatible with other cases around the country?
The allegations about to the extent that we had them at that point, of the Republican inspectors who had been herded aside and put into pens, because that was similar to the allegations in 4 or 5 other places that happened contemporaneously.
Anything else that you added that you can recall?
Yes, but I can't recall right now. I mean, but that was one of the main things that we added.
And as the lead lawyer, as you were effectively supervising Mr. Hicks and you approved the initial complaint before it was filed?
Yeah, I mean, I'm not begging off this. I'm just trying to give you the truth. I relied greatly on Hicks. He had a great reputation. As all of us would do when you first work with a lawyer. I checked him out as quickly as I could with people who work with him and know the Philadelphia bar, and they told me he's a very fine lawyer. And I found his work to be excellent.
And would it be fair to say that that he took the lead, at least in terms of state law issues that might come up? Or
Well, yeah, he was, up until the point that he said he had to leave, he was going to argue the case. He wanted me to be there. He thought that I could. He was impressed that there were similar situations elsewhere, so similar to his, and he thought it would be helpful. But I was intending to argue for about 5 minutes.
so you didn't sign the initial complaint because you were not admitted pro hac at that point, right?
Yeah, I mean, I might not have signed it even if I was. My contribution was minor.
Okay.
And it was really his product, and a good one.
And obviously sometime after the initial complaint was filed, there was an amended complaint was filed, right? It was the first amended complaint.
That's correct, sir.
And my understanding is that the first amended complaint withdrew some allegations that had been contained in the initial complaint.
Yeah, I took it down to 2. I'd have to look to remind myself what the first complaint had. I took it down to only 2 counts. 1 equal protection, 1 due process. It sort of had this omnibus clause in it that reincorporated by reference everything else, but it was very unspecific.
Okay, my understanding, maybe I may be wrong, from the testimony was that the initial complaint was amended and certain allegations or claims were taken out of the complaint and essentially deleted from the first amended complaint. Am I right on that? Or
You're absolutely correct, and I would add the word substantially changed. It was taken from this page to that.
how much? What was taken out of the first amended complaint, the first complaint that did not appear in the amended complaint? Do you recall?
I don't now recall exactly what was taken out. I recall it was a great deal of it. But my concern really, when I tried to do surgery on it, was to kind of ignore it and just go back to Hicks' complaint, use that as the basis for the second amended complaint, which I think I've told you I did. That was sort of the prototype and then add on the second amended complaint a few of the additional things we had found out.
So, I mean, you were involved with the initial complaint. Who was responsible for filing the first amended complaint? I mean, who made the deletions from the initial complaint and did not include them in the first amended complaint?
Linda Kearns, who was, as I understood it, Mr. Hicks's assistant. She claimed to be his equal co-counsel. Everyone else, including Mr. Hicks, described her as his assistant. She made those changes, filed it, and I found out about it after it was filed. And at this point, this was after Mr. Hicks had to withdraw from the case. So maybe I should.
Why did he withdraw?
Well, he first called me very upset, saying that there was a lot of pressure being put on him by his law firm to withdraw. He said he was not going to withdraw, not to worry. And then we just went on and talked about the case. We didn't have, and then.
Did you come to understand why Ms. Kearns?
Well, then he called me. I'm sorry.
Wait till I finish. Did you come to understand why she made the changes that she did before she filed the first amended complaint?
I understood in retrospect that she never agreed with the first, that she and Hicks were not of one mind on the first complaint.
What was it that she disagreed with in terms of the first complaint?
I don't know. She wasn't around long enough, nor did I have the time to be able to figure out. Honestly, I don't think I ever knew what exactly it was that troubled her about it. It could have been this is gossip. Well, okay. Could have been personality. I don't know.
Now, when
There was the odd circumstance that he was considered the lead counsel by everyone that talked to me there and in Washington, and she kept describing herself as co-counsel. So you know how lawyers are.
So in the Middle District of Pennsylvania, you represented the plaintiffs, right? There were 3 plaintiffs.
Yes, we represented the campaign and Donald Trump, and we represented wasn't it two plaintiffs?
It was a Lawrence Roberts and David John Henry.
Yes, and Trump. So three plaintiffs.
Those were your 3 clients, right?
Right.
And who were Mr. Roberts and Mr. Henry?
They are citizens of, I think one's Luzerne County. I've forgotten the other county, and they were there to illustrate the denial of due process based on the cure provisions that were applied in some parts of the state, but not in other parts of the state because of the confusing advice given to them by Bookvar's office.
Okay, so as I understand it, neither one of them lived in a county, in a defendant county, correct?
That is correct, but they were the thinking that Hicks had was that they were disadvantaged. Okay, I'm sorry.
I'm not done.
All right.
So don't confuse me. I'm just trying to work my way through this.
Okay, thank you, sir.
So they voted in. Were they from the same county or 2 different counties?
2 different counties. 2 different counties.
So they respectively voted in the proper county, neither of which was a defendant in the case, and their votes were rejected, correct?
They weren't allowed to cure their votes
Okay.
the way the people were in the counties that were defendants. Yes, sir.
And were they challenging that decision not to allow them to cure their votes?
I believe they did. Yeah.
So-
I'm not sure. I'm not sure because that predated me exactly what they did before I got into the case, what they did in their county. So I shouldn't say that.
I thought the testimony was that, or I saw it somewhere that they were not allowed to cure their votes, and they did not challenge that decision.
That could, well, that could be right.
Now, both Mr. Roberts and Mr. Henry sued the Kathy Bookvar and 7 counties. Can you tell me what their claim was against the 7 counties in which they did not reside?
That
I'm lost.
Well, their claim was that illegally, they were allowing curing of ballots, which created the disparate condition in their county. They didn't want to, or Mr. Hicks didn't want to sue those counties because those counties were following the letter of the law. And it's the counties that allowed the cure that weren't. So his thinking was that they were the ones creating the injury. And creating vote.
And what is the nature of the injury to him from the allowance of votes to be counted in by the defendant counties?
Vote dilution.
Well,
All of these allegedly illegal votes are counted, which dilutes the vote. And in their particular case, didn't allow them to vote on the same basis as others.
so his theory was that allowing others to vote diluted the his vote. I don't understand, because he was.
It diluted the vote of the entire county, and in their case,
Yeah, but he's the plaintiff, and he didn't vote because he didn't follow the appropriate procedures. So how
well, he did.
does the voting in the defendant counties dilute a vote that he was never entitled to cast in the first place?
Well, the vote that he wasn't entitled to cast in his county, he wasn't entitled to cast because he followed the letter of the law. The vote that they cast was contrary to the law.
So if he was
And therefore, that
concerned,
diluted the legal vote.
if he was concerned about dilution of his vote, why didn't he bring a claim to allow his vote to count? And why didn't he sue the county which denied him the right to vote?
Because he didn't allege or agree that the county had acted improperly, but that the other counties had acted improperly in allowing people to vote that weren't entitled to vote.
And so that based on the fact that Mr. Roberts and Mr. Henry were properly not entitled to vote, you, on their behalf, sought to invalidate every other voter in 7 counties that had been granted the right to notice and cure?
Well, sure. I mean, the right to notice and cure was not that was the illegal part of it. Those votes shouldn't have been counted in the first place.
So that was the underlying nature of your equal protection and due process claims brought on behalf of Mr. Roberts and Mr. Henry, right?
That's correct. And on that, we didn't ask for specific. On that, we would have certainly been willing to accept a new election.
So based on the fact that these 2 plaintiffs were properly denied, in your view, the right to vote in their county, you thought a court would grant a new election?
Depending on the number of votes, we had no idea how broad the practice was of cure. If it were only the number we were alleging at that point, surely not. But if the number were much, much larger, then it would have had a material effect on the outcome of the election.
So these 2 plaintiffs had a claim that, based on what happened with their votes and the notice of cure, they were entitled to an order negating every other notice and cure vote that had been allowed in the entire state.
Well, not really. In the counties that had been
In those 7 counties.
depending on whether it had a material effect on the election. So what we had the beginning of a case, we didn't have the end of a case.
Did you really think that any court in Pennsylvania would grant relief like that to these 2 plaintiffs?
I thought it was conceivable if it was broader than the numbers that we started with, yes. And also combined with the Trump voter dilution.
Let me ask you about these.
You know, in a case with standing, if one of the 3 has standing, that's sufficient. So it didn't rest on its own. It rested also on the Trump standing.
Let me ask you about the. You've testified, I think, a few times about some declarations, and By declarations, I think they're declarations or affidavits. And you've said the number estimated about 300. Is that
Yeah,
I-
it turns out to be about 240, but I had said 300, correct?
okay? Those 240 declarations were of some of them raised what you say are allegations of fraud on their face. Others raised the notice of and cure issue. Others raised the observer distance issue. Is that fair? Am I understanding that correctly?
Perfectly, yeah, but in very different proportions.
Right, yeah, and I'm not
One-
gonna ask, I'm not gonna ask you how many of which, but does that basically cover the waterfront in terms of their content?
No, what- I have it, I made a list of them. They are exclusion from observing the vote,
Okay.
various different ways. Not allowing people to vote who had claimed they didn't vote, but there had been an absentee ballot executed for them, of which there were many. That was a large category, much larger, for example, than notice and cure, which is why I think those aspects of the case would have taken over, which relates to Trump's standing. A significant number, slightly different, that came in to vote on election day and were allowed to file a provisional ballot. They did claim that there was a false vote entered for them. They never voted absentee. Now you put that number together, it gets up to about 70. Many of them, not everyone, cast a provisional vote. Many of their provisional votes, when they went back and checked, were never counted. I'd say the majority of them were never counted. So in their case, if there were 70, 55 or so were deprived of the right to vote because somebody had falsely entered an absentee ballot in their name using their registration to cover their phony ballot. That was maybe even larger than the number of people that had been excluded from observing the ballots being counted. The number of people being excluded from seeing the ballots was also around 60 or 70. And they were in categories ranging from not seeing ballots for being excluded for half a day, and they didn't bother to count them. They just gave you a general feeling, 100, 200, 300. We didn't count those.
These are all that they were in the universe of about 240 documents, declarations.
Yeah, I'm trying to tell you the ones that were the most significant.
I'm just trying to get the aggregate number.
So some of them, so of the universe that was excluded from seeing ballots, they range from someone who didn't see a couple of hundred ballots to some that didn't see a couple of thousand ballots and kept records of it.
Yeah, I'm just talking right now about the declarations themselves.
Well,
I understand you say that some declarations refer to one incident, some refer to more than one incident. But you had a total of about 240 declarations. At what period of time did you assemble these? Was it before the First Amendment complaint? During that period of time? When is the best understanding that you have now when you got those?
pretty much from the first day, I began that with that conversation that I described to Judge Leventhal before. That began immediately when Mr. Mercer gave me the list, because that was our first group of witnesses. He said, these are my people who observed this not only here in the arena, but they observed it all over Philadelphia. He also told me he had been in contact with his counterparts in Pittsburgh, and he said it's very strange.
Okay.
But
Mr. Giuliani, just, you're giving me too much information now.
I'm sorry. I'm sorry.
You got all of these declarations around the time of the filing of the complaints, and I think you told Judge Braun they were still coming in.
Yes, they were.
Okay. And so when was the last, when did you receive the last of these declarations?
I don't know.
Was it about around the time, at least, of the Third Circuit decision in the case?
Yeah, I would assume. I mean, frankly, we probably lost some interest in it at that point because we had to turn our attention to other,
Right.
To the hearing in Michigan and to the hearing in Arizona and that sort of thing.
Right now, Mr. Fox's office requested that you produce all of those declarations, right?
Yes, he did.
And about how many did you produce?
We produced all that we had. I didn't keep any behind in my office.
About how many is that?
That's about the two, probably the number you see in our exhibit.
Was it the attachments to the letter? There were about 15 exhibits?
Oh, no. That letter was just a brief letter to try to give a few examples. We did not attach all that we had then. We attached them to our answer to the more formal complaint.
But there are some, what efforts did you make to retrieve declarations that were not in your custody?
I called all the people that I work with. In fact, I did retrieve some. So I should amend that. When we made our original major turnover, I took everything that I had. I may miss somebody, but I called Christina Bob. I called Giuliani Allen. I talked to Bernie Carrick because I see Bernie on a regular basis. I talked to Dr. Ryan, said, please give me anything you have. Talked to Boris Epstein, Mike Roman. I asked them to please give me what they had that they had originally given to me, but for some reason had kept or took and they did. They sent me documents, and those documents were included in the original disclosure of documents. And then since then, a few others have come in, and those are the ones that we've produced, later.
Okay.
There was no, I can assure you, there was no, we want you to have everything that we have because we think it justifies at least the basis for our case, whether you agree with it or not.
I apologize if I'm being repetitive here, but could you explain to me the equal protection claim that was asserted on behalf of the individual plaintiffs?
We're talking about Trump now as well?
Oh, as the individual, Mr. Roberts and Mr. Henry, I think the names were. As succinctly as you can. I'm just trying to orient.
I know you're having trouble with it, but the equal protection claim was that in other counties in the state, people were allowed to vote on an interpretation of the law that in their counties were regarded as illegal and were not available to them. So therefore, they were deprived of their right to vote, where other people were granted the right to vote on an illegal basis. That directly injured them. Number two, it diluted vote in general, and it diluted the vote for Trump, who was their co-defendant. And the law of standing is that if any one of the three has standing, you have standing.
Well,
And I should emphasize
Why-
without trying to escape it, I should emphasize that that was part of the case when I came into it. And I didn't develop that theory. I agreed with it.
why did they not bring a claim against the counties that denied their vote?
Because Mr. Hicks believed, and I agreed, that they would have lost that because the counties were following the law, at least the way we also interpreted it. And it was the counties that were violating the law that were creating the disparate treatment of them and then of all the Trump voters.
All right, thank you, Mr. Giuliani. Mr. Brozos, do you have anything?
Yes, I do. Thank you, Mr. Bernius. And Mr. Bernius, you asked a number of questions that I was going to ask, so I think we can speed this along. Mr. Giuliani, you indicated that you were brought in by former President Trump to coordinate the national effort. Is that correct?
Yes, sir. That's correct.
And you went, and I want to get back to that in a second, but you went to Pennsylvania at some point shortly thereafter. And the matter was being prosecuted at that time by Mr. Hicks. Is that correct?
That is correct.
And Mr. Hicks, you said, was a very well-known established lawyer. And I think you said Philadelphia.
That's right. Yes.
Pennsylvania had an established procedure to challenge presidential elections on an expedited basis. Is that correct?
I'm generally aware of that, but I'm not, an expert on Pennsylvania law. I'm sorry.
Well, I thought maybe Mr. Hicks could help on that matter. What I'm not understanding is why an established procedure for challenging a presidential election wasn't followed. Do you have any idea?
I'm very sorry. He explained it to me, but I don't remember it. And you have to understand, I know that sounds strange, but this all happened in 2 days. Our interchange was pressured enormously by the time when I met him, he was working on what you see as the first complaint with the two. He met with and interviewed the two gentlemen that Mr. Bernius asked me about.
Right.
He had already done a substantial amount of work putting together that first complaint, which is why I got it so quickly.
And I understand that. But there was no subsequent, preliminarily, there was no discussion, or there was a discussion, but it was never brought up again.
There was a discussion that I recall about, I would have thought I might have asked if we exhaust state remedies, or because that's the way I probably would have looked at it from my litigation practice. And he explained to me, I'm going to be guessing a little because I got so many. I'm pretty sure it had something to do. They had a history of, they meaning Mr. Hicks, Linda Kearns. They had brought previous litigation there about the election.
About this presidential election?
Challenging some of the changes in the law. I'm a little foggy on this, but they had brought other cases basically challenging the executive changes that were made without legislative approval. And I do believe they felt that it was a lost cause to litigate it to litigate this in a Philadelphia court or in a local court. They thought, and I hope not to offend anyone, but they thought the die was cast as to how the court would come out. And therefore, as lawyers do, where you try to choose the right venue, they thought they'd have a better chance in federal court.
Okay. Going back to something Mr. Bernius was referring to on the notice and cure. The Secretary Bookvier issued guidance that the counties could or could not implement it. It was up to them to implement notice and cure. Is that correct?
Yes, I think that was the final. There were several iterations of that, but I think that was the final one that came out right near the end of the election. Yeah.
So it was chosen by those counties that the plaintiffs resided in. Those counties decided not to implement it, although she said, it's up to you.
Yeah, and those counties, in the few that I had a chance to talk to, had gotten legal opinions that it was illegal. What she was telling them to do would have violated the law, and she has no right, as you know, to change the law. The law with regard to elections, whatever the outcome of the new Supreme Court decision, gets set by the legislature, not by the executive. All the executive gets to do is a ministerial function. I mean, that's pretty strict constitutional law. So not only would I have,
I'm sorry,
I would have agreed with that if I were the mayor I wouldn't have done that. And if you look at who followed it and who didn't, there's a very partisan cast to it.
Okay. Let me move on, Mr. Giuliani, to the issue about the observational boundaries. First, and I think you acknowledge that these observational barriers, one of the impetus may have been or was the COVID outbreak. Is that correct?
That was the purported reason given, contradicted, more than followed by the numerous people that walked up to the people standing there and sitting there without any mask, much more than 6 feet. It seemed as if this was only something that might affect a Republican.
And I'm a little troubled by that when you say that, because I thought you had indicated that both Democrats and Republicans were subject to the same thing in large part.
I said that Democrats were subject to it, but when there were exceptions made, it was made only for Democrats. And of course, the officials sitting there are almost all Democrats, appointed by, for example, the Philadelphia Democratic Party, well known as machine employees. I mean, you have to have your head in the sand not to know that.
These observers, am I correct, cannot challenge a ballot?
I think you're right. I think their function is to record it for future litigation.
Okay. Yeah, my reading is that they could not challenge the ballot. So it was more purely observational. And I was struck by one thing. You indicated, I believe, very early, you met with Attorney Mercer, who is highly respected, according to you. Is that correct?
Yes.
And Mr. Mercer provided several affidavits, I believe at least two affidavits that you used.
Yeah. Yes, I have two.
And those affidavits talked about observational boundaries and problems observing what was going on.
You know, they pretty much, can't say 100%, but they pretty much track what he told me orally. I hate to introduce a complication, but I do think Mr. Mercer was also involved in other litigation, so there might be other affidavits of his. I tried to get them once, but I couldn't.
Okay. here's where I got a little confused. The Supreme Court heard this issue on observational boundaries. Is that correct?
Supreme Court of Pennsylvania, yes.
Pennsylvania, yes.
Yeah, that- almost immediately, right?
Right. And one of the witnesses called was Mercer, Attorney Mercer.
That's right.
And I don't have the exact language, but the language that I wrote down was that Attorney Mercer was deemed a credible witness by the Supreme Court.
Okay.
That was testimony this morning. And
That was a mischaracterization of the word meaningful. The conclusion was that his presence was meaningful, and the reality is he never got to within a football field of seeing anything.
but he did testify apparently to the Supreme Court that his ability to actually, he was not deprived of the ability to actually observe the process in any meaningful way. That was,
Have you seen that?
Well, that's what the decision says. Yeah.
No, I haven't seen that. I haven't seen that testimony, and that I don't interpret their paraphrase of it as
that was the Supreme Court's language.
it was their language. But what they mean by meaningful is being in the room. That the whole decision decides that being in the room is meaningful. So that doesn't tell you anything, sir. I'm sorry.
Okay,
That's like circular.
but that his ability to observe was not in any way affected in any meaningful
But he
way.
doesn't say that. He
Okay.
says quite
Okay.
clearly in his affidavits over and over that he saw nothing.
Well,
And they decided that was okay because your presence in the room was meaningful, which I think is an absurd decision. An absolutely absurd decision.
okay,
It means that you could be a potted plant in that room. If you didn't see anything, you still complied with their ruling. There was no requirement that you see anything. Now, what the heck are you doing there if it isn't to see something? Which I think Judge Cannon was correct about, and the dissenters. And I also would say it certainly gives me, I hope, the clear defense that I was making a reasonable argument, because I was making an argument that 3 judges agreed with. I'm
Okay.
surely entitled to make an argument for my client that 3 judges agreed.
Well, Mr. Giuliani, thank you. I believe that's all I have.
Thank you, sir.
Ms. Merle, do you have anything? You're on mute.
Mr. Giuliani,
Yeah, I'm sorry. I can't hear you, Ms. Hainsworth Moreau.
Mr. Giuliani,
Now I hear you. Yes, sir. Yes, ma'am.
thank you very well. Were you, did you enter your presence at the court to represent the clients, or were you working with Mr. Hicks? At any time when Mr. Hicks removed himself from the case, did you then enter yourself?
I was an attorney. I was one of the, yes, I was an official. I was as allowed pro hoc vice. I was allowed as an outsider to practice for the purpose of that case, which is quite common. And the principal lawyer first was Mr. Hicks, and then Mr. Scaringi, along with Ms. Kearns, who the judge would not allow out of the case because he felt that we, Scaringi and I, were in it too briefly to really understand it. And I think that reflects part of the problem.
Thank you.
Thank you very much, ma'am.
Mr. Fox, do you have anything additional?
No,
Mr. Levitt, any follow-up?
I did, I forgot one thing, if I may, very quickly. Mr. Fox, oh, I could sit down. I thought I was going to the screen again. Mr. Fox had mentioned that Judge Diamond had entered into a stipulation with the parties when they weren't honoring Judge Cannon Fasano's order, which was in effect on November 5th. And Mr. Fox was kind enough to send me early this morning. I think he was up all night, but he sent it to me early this morning, the transcript of the hearing or the consent, and that they agreed that they could get closer to the
Mr. Leventhal, just excuse me, at this point, do you have any further questions of
I
Mr.
do.
Giuliani?
I do, but I want to say, I want to refresh what had transpired. Mr. Fox had mentioned that Judge Diamond did a settlement that they can get closer. Mr. Giuliani, after that, was there still remain a problem in observing in a meaningful way in Philadelphia, at least, and in perhaps other jurisdictions? You can't nod your head, you have to answer.
No, I am. I was just waiting to get. I was just waiting to get the microphone. The answer is the answer is yes. The problem remained. It only abated in some places the last day or two.
Day or two of what? Not yesterday.
No. Like the whole counting went on for about 7 or 8 days. The 7th or 8th day, there was some access, not in Philadelphia or Allegheny, as I understand, but some of the other counties. But there also are affidavits in the file of people who were excluded after the settlement and complained about it.
And yes or no, will we have a witness who will testify to that?
Yes, there are several.
Okay.
Yes, in the file.
All right, that's all. I said it would be brief.
Mr. Fox, anything else?
no.
I think you're done, Mr. Giuliani. Thank you. Mr. Fox,
Thank you very much.
think you're going to bring your next witness on now. We can
Right.
take our mid-afternoon break and then resume with the next witness.
That's correct. He's right here, Mr. Ortiz.
Okay, we'll break until 3:45.
I
Thank you.
will open up the breakout rooms now.
Thank you.
Okay. We're back on the record. Mr. Fox, your next witness, please.
Daniel Ortiz. And I guess, Dan, you just unmask or need to unmute, yeah.
Here I am.
Mr. Ortiz, do you solemnly swear or affirm that the testimony you will give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, proceed, Mr. Fox.
Please state your name.
My name is Daniel R. Ortiz.
And Mr. Ortiz, where are you testifying from?
I'm testifying from a town called Ascoli Piceno in the region of Le Marche in Italy.
And what time of day is it there?
It is now about 10 minutes before 10 p.m.
Okay. Tell us about your educational background, where you went to college, where you went to law school.
I graduated from Yale College with 3 majors in 1978. Then I went to Oxford University as a Marshall Scholar and got an MPhil in Shakespeare and English drama until 1640. And then that was in 1980. And then I went to Yale Law School and received my JD in 1983.
And what has been your employment? What was your employment immediately after law school?
Immediately after law school, I worked as a summer associate for Curvasoin and more in New York City for a few months. And then I began a clerkship with then Judge Stephen Breyer on the First Circuit in Boston.
And after your clerkship with Judge Breyer, where did you go?
Then I moved to Washington and clerked for Justice Powell for a year.
Okay. What has been your employment since your clerkship with Justice Powell?
After taking a short vacation after my time with Justice Powell, I started at the University of Virginia School of Law in 1985. And I've been teaching there ever since, except for a total period of 3 years when I visited away at other law schools at different periods of time.
And which other law schools were you visiting, Professor at?
The University of Southern California and Berkeley.
Can you tell us what your experience has been with election law?
Yes. When I was a law student, I wrote my student note on election law. Then I started teaching election law a few years after I landed at UVA. And I have co-chaired the election law committee of the section on administrative and regulatory practice for the ABA. And I was chief of legal advisors for the National Commission on Federal Election Reform that was set up after the 2000 presidential election. And I've written articles on election law, of course, as well.
Can you just tell us a little bit about what that commission was for whom you worked?
That commission was set up after the 2000 election to make recommendations. It was a bipartisan commission. It was headed by former presidents Ford and Carter. And came out with a report, actually several subsidiary reports on various aspects of the election and made recommendations as to how to reform things going forward.
Finally, as a law professor, have you taught civil procedure?
Yes, sir. I've been teaching federal procedure fairly regularly.
I would move Mr. Ortiz in as an expert witness in the areas of election law and civil procedure.
Mr. Cammons?
No objection.
All right,
Would you display to the witness Disciplinary Council Exhibit 40 in evidence? Can you just tell us what this is, Professor Ortiz?
That's the expert report I submitted in this proceeding.
Okay, thank you. You can take that down now. I'd like first to start with a discussion about the responsibilities between the federal government and the state government for the conduct of elections in the United States for federal office. Could you just tell us how that responsibility is divided?
There are two primarily relevant constitutional provisions. In Article 1, there's the so-called Elections Clause, which allows the states to set the time, places, and manner of congressional elections subject to a federal override. And then in Section 2, there's the so-called Electors Clause, which gives the states even more authority with respect to choosing presidential electors. The federal government can specify the date that the electors are chosen and the date that the electors have to cast their vote in the electoral college. But that date, the second date, has to be the same for all states.
With respect to the actual conduct of an election, who has the primary responsibility?
That is determined by the state, and just about every state has devolved most of that authority down to the localities, whether counties or cities, with some state guidance.
Okay. In terms of procedures, such as procedures to monitor elections, who determines what those procedures are? Which body, or which governmental body?
The state governments.
Is there any federal requirement that elections have poll watchers or election observers and so forth?
In general, no. There is a provision in the Voting Rights Act of 1965, which allows the Attorney General to appoint federal poll watchers in certain circumstances. That provision was used not irregularly during the 1960s and 1970s after initial passage of the act. It's still used today. I believe in the last 2020 election, there may be around 25 jurisdictions of like the county level or something like that, where federal poll watchers were appointed.
And aside from those jurisdictions that are covered by the Voting Rights Act, is there any federal requirement about how many poll watchers, or even whether to have poll watchers?
No, sir.
Now, with respect to the decision of how to vote, and I mean by that whether by mail or in person, who has the authority to make that determination?
The states.
And prior to the 2020 election, are there jurisdictions in the United States where no question mail-in voting has been permitted?
Yes, there were many of them. The most prominent would probably have been Oregon, which in 1995, I believe, had a federal primary election held completely by mail-in voting, and in 1996 had a federal congressional general election, I believe it's senatorial, held completely by mail-in voting.
Now let's come to the issue of election disputes and recounts and that sort of thing. Again, where is the authority, the primary authority, to resolve those matters?
In the states.
I know difficult to generalize about 50 states, but do those states generally have procedures, special procedures for something like an election contest?
Yes, sir.
And do you know if Pennsylvania had such procedures?
Yes, sir.
And those procedures call for expedited treatment of such election contests?
Yes, sir.
Now, under what sorts of circumstances is it appropriate to bring a challenge to a state-run election in a federal court? In other words, what types of issues do the federal courts have jurisdiction to hear?
Well, the federal courts have jurisdiction in cases involving federal laws, whether statutory laws or constitutional laws. So if there's an argued violation of the 19th Amendment or the 14th Amendment or the First Amendment or something like that, the case could be brought in federal court. It would be brought as an ordinary, what's known as a Section 1983 case, an ordinary civil case. which would concern whether state officers acting under color of their authority violated federal law.
And so those would be constitutional challenges to the state procedures. Is that correct?
Well, they could be statutory as well.
Federal statute too.
Yes.
Okay. But the federal government does not have the authority generally to enforce the state statutes, right?
Well, there could be situations where state statutory claims are brought along with federal statutory claims, and the federal courts might decide those. Typically, they defer to the states and don't decide those unless they absolutely have to.
Now, there's something called the Anderson verdict test. Are you familiar with that?
Yes, sir.
And what is that?
It's a case that applies to equal protection challenges of mostly garden variety or administrative questions. In Anderson versus Calabrese itself, presidential candidate John Anderson from the 1970s was challenging the length of the period before the election that an independent candidate had to file signatures and things like that. In the Burdick case, which was about the same era, concerned Hawaii's the constitutionality of Hawaii's write-in voting provisions.
And
then get in the case, and sorry, to be more responsive, the test itself basically balances the burden on the individual interest against the weightiness of the state's interest. And it's kind of sliding scale or balancing test. And it gives the states much deference.
And when you say much deference, what would an individual have to show? What kind of a burden would the individual have to meet to show that the state procedure was unconstitutional?
Usually a very heavy one.
Okay. Now, you've listened to the hearing, watched the hearings, I guess is a better way to say it, so far, correct?
Yes, sir.
And did you hear Mr. Giuliani's testimony yesterday about a substantive due process argument arising from the inadequacy of the Pennsylvania security procedures for counting mail-in ballots,
Yes, sir.
specifically the lack of observation?
Yes, sir.
Okay. And do you have an opinion on the validity or on the viability of that argument?
I would agree with the Third Circuit, which said that
I would object, excuse me, I object to the question.
Overruled.
I would agree with the Third Circuit, which said that the substantive due process clause does not regulate the distance to how close observers have to be to the actual counting of the votes, or what their particular vantage point has to be. That's a matter of state law.
And you're referring to the Third Circuit opinion in the Bachvar case, correct?
Yes, sir.
Let's put that up. That would be Disciplinary Council Exhibit 16. And this is the Third Circuit opinion to which you're referring?
Yes, sir.
Okay. And if you will go to page 9, page stamp 9. And if you'll blow up the second paragraph on the second column. That's the one. Is this the language to which you were referring in the that dealt with the substantive due process issue?
Yes, sir.
And just read to us the language to which you had alluded.
Count 7 alleges that Philadelphia's Board of Elections violated due process by obstructing poll watchers and representatives. But nothing in the due process clause requires having poll watchers or representatives, let alone watchers from outside a county or less than 18 feet away from the nearest table. The campaign cites no authority for those propositions, and we know of none. Ditto for notice and cure procedures. And the campaign litigated and lost that claim under state law too. The Pennsylvania Supreme Court held that the election code requires only that the poll watchers be in the room, not that they be within any specific distance of the ballots. And then it cites in-ray canvassing observation.
Okay. Thank you. We can put that down now. Can you give us some idea of the frequency with which the federal courts intervene in state conducted elections?
It's very infrequent.
Now, there's a case that's been mentioned here from the Third
I'm
Circuit.
sorry, excuse me, Mr. Fox, I didn't hear the answer. Was it very frequent or very infrequent?
I better let
Very, very infrequent.
Oh, thank you. Sorry.
That's okay.
No, I'm sorry.
And we've had testimony about a case from the Third Circuit called Marks v. Stinson, Stinson. Are you familiar with that case?
Yes, sir.
And that was a case in which the federal court intervened in a state election, was it not?
Yes, sir.
And tell us about that case and why the court did intervene in that particular case.
It was a case involving a Senate candidate from Philadelphia, and there were allegations which were supported in the record by much evidence that the Democratic candidate Stinson had conspired with members, I believe 2 members of the local election board to basically file absentee ballots that were illegal. And at one point, they were rejected by the workers at the election board when they were originally submitted, and they were ordered against the law to somehow be fixed, and more ballots were sent out. It was a scheme concerning many, many ballots in a regime where there was no excuse in mail voting. This was still the days of absentee voting, where you could only obtain an absentee ballot for very specified, a particular set of reasons. And in that case, the Third Circuit found that the district court's findings that there was extensive and deep fraud, which could have affected the outcome of the election, it was upheld. Although it's in its initial decision, it reversed the district court's remedy, which was to declare candidate Marks the winner of the election. And the Third Circuit said that unless it could be shown that but for the constitutional misconduct and violation, the other candidate would have actually won the election, that he could not be declared the winner. But when it was shown that the candidate could have won the election, the remedy was up to the discretion of the district court. While the district court couldn't declare the loser the actual winner, the district court could grant an injunction against the certification of the votes, could declare that the seat was vacant, and allow the state authorities to carry on, could order a new election, all that. Then the case went back to district court because there was this question about whether, although in the initial district court proceeding, it was not shown that the irregularity, but for the constitutional violation, candidate Marks would have won. That was still an open question. And so the Third Circuit sent it back to the district court for more proceedings. And there were, as I understand it, 3 experts involved. There was one for each candidate, and then Professor Orly Ashenfelter from Princeton University. And basically, remarkably, all 3 experts, including the expert for the candidate who had won the election with the invalid absentee ballots, agreed that candidate Marks would have won but for the constitutional violation. And so at that point, the district court declared candidate marks the winner, and that went up to the Third Circuit and was affirmed. Cert was sought but was not granted.
And do you remember what the margin of victory for the winning candidate was initially in that election?
I believe it was around 500 votes.
Okay. Now, the other case that I want to talk about is Bush v. Gore, which I take it you have some familiarity with.
Yes.
And explain, if you will, to the panel what the issue was in Bush v. Gore.
Well, in the Bush v. Gore decision, the Florida Supreme Court had ordered a recount of some ballots. And the standard under Florida law was that the ballot should be counted for the candidate where the intent of the voter could be determined. And the Florida Supreme Court instructed that the recount should be conducted under that standard. The Bush campaign complained to the United States, among other reasons, to the United States Supreme Court, and among other reasons, that this created an equal protection violation because the intent of the voter standard, although that was the official standard of the state of Florida, was ambiguous and uncertain enough that as different districts, in fact, different individual workers could interpret it differently for the same ballot. So, for example, some might have, in a jurisdiction that used punch card voting, some might have counted a dimpled Chad as revealing the intent of the voter, whereas another worker might have not. There are other kinds of technologies involved in things like that. And the United States Supreme Court said that when a single official or state institution, here the Florida Supreme Court, has the capability of instructing that a recount proceed with more definite standards that wouldn't lead to these kinds of differences in interpretation that could be arbitrary, that it has to do so. And that if it doesn't, as it didn't here, because it just instructed the recount to proceed under the vaguer intent of the voter standard, there was an equal protection violation. And so it halted the recount.
Well, what was the split with the court in that case?
It was 7-2.
Okay. And what did the court say? What, if anything, did the court say about the limited nature of its ruling?
The court basically, as I believe Mr. Giuliani stated, gave indications that it was not, the decision was not to be applied too broadly and across the board, and it hasn't been.
Let's take a look at Respondents Exhibit 37, which is the opinion of Bush v. Gore. And you've gone right to the page that I want you to go to, I think, which is page 37-6. Is that where we are? No, you're at 4, I think. Okay. And if you, I don't think that's it either. Yeah, you're still on page 4. We need to go to page 6. Okay, if you could just highlight the 2 paragraphs in the right column that begin with the recount process. That's right. And can you point here to the language that suggests that the case is pretty much limited to its facts?
That'd be the last sentence of the first paragraph. Our consideration is limited to the present circumstances, for the problem of equal protection in election processes generally presents many complexities.
Okay. And did the court also comment on the ability of local entities to conduct elections in different manners or by different systems?
Yes, you mention of that in the first sentence of the next paragraph. The question before the court is not whether local entities in the exercise of their expertise may develop different systems for implementing elections.
Now, you said a moment ago that the case has not been followed, frequently been followed. Is that correct?
Yes, sir.
Are you aware of any case in which a federal court has overturned an election based on Bush v. Gore?
No, sir.
All right, since it was decided,
No,
right?
sir.
Okay. All right. Let's turn to the procedures in Pennsylvania in 2020. Are you familiar with something called Act 77?
Yes, sir.
And what is Act 77?
Act 77 was passed in 2019, I believe, and it moved the state from traditional absentee voting, which was allowed with specific reasons, to more general mail-in voting at the request of the elector.
And in general, what was the process that a voter had to go through if he or she wished to vote by mail?
Well, a voter had to already be registered, of course, and then that voter had to apply for a ballot. And the first statewide ballot would have been the primary of 2020. And the person had to state that they were eligible to vote and fill out other information that was required by the state to apply for the vote. And then also, I believe, state whether they wanted the system to be registered for continue to be able to do mail-in balloting in the general election as well.
Now, just to stop on that last for the moment, what you're suggesting is that if you applied in the primary election, you could indicate whether you wanted to vote in subsequent elections by mail?
I'm not sure it is all subsequent elections. That's the way it is in some jurisdictions, but I believe that you could indicate at least for the general election that year.
Okay. What, if any, requirement of proof of identification did Act 77 impose?
I believe that you had to send in a copy of your driver's license. I'm not sure.
Okay. The pandemic, as we all know, began in roughly 6 months after Act 77 was enacted. What was the effect on that in the mail-in voting in Pennsylvania in the 2020 elections?
Well, many more people were interested in mail-in voting after the pandemic began, because it meant that they wouldn't have any issues with social distancing and going to the polls.
Okay. Now, prior to the general election in 2020, was there litigation in the state courts concerning the procedures that were to be followed in implementing Act 77?
Yes, sir.
All right. Are you familiar with a Pennsylvania Supreme Court called Pennsylvania Democratic Party v. Bakvar?
Yes, sir.
All right. Can you just tell us what the Pennsylvania Supreme Court held in that case?
Well, there were, if I remember, 5 major holdings. Perhaps the most important one of this litigation was that the election boards were not required to do notice and cure, but the court didn't say that they could not do it, that it wasn't permissible. The court also held that the use of drop boxes was okay. It held further that mail-in ballots dated 8 p.m. on election day and received up to 3 days later could be counted. It held the ballots that came in that were not contained in secrecy envelopes could not be counted. And it upheld the residency requirements for poll sort of canvass observers.
Now, this was a statutory interpretation of Act 77, is that correct?
Yes.
And what was the rationale behind the reasoning that the court gave when it said that the election boards were not required to offer notice of cure?
It said that there wasn't language in the statute that indicated that obligation.
Okay. And did it point to any language in the statute that forbade that obligation?
No, sir.
Okay. All right. Now let me come to another pre-election ruling in the state court, and that was, sorry, let me come to a pre-election ruling in the federal court. There's a case called In Re November 3rd, 2020 general election. No, sorry, I got myself tangled up. It is a state court. So let's go back and start again. The Pennsylvania Supreme Court opinion in Re November 3rd, 2020 general election. Are you familiar with that opinion?
Yes, sir.
That's an opinion that is called a King's Bench jurisdiction matter. What's a King's Bench jurisdiction matter in Pennsylvania?
I believe that's a form of the Supreme Court's original jurisdiction.
Okay. And again, was this another statutory interpretation case?
Yes, sir.
All right. Tell us what the Supreme Court held in that case.
Well, there are two primary holdings. The one was that the election boards were not to make signature comparisons in canvassing. And the second was that the canvass observers could not challenge the mail-in ballots in the canvassing process. So it noted that it noted that people could challenge mail-in voters up to the Friday before the election, but once the ballot came in and you were in the canvassing process, no one could object because of any problem with, say, the outside envelope or something like that. That had to be done by the canvass workers themselves.
Do you remember what the court's rationale was for why signature comparison wasn't to be done during the canvassing process?
Well, one of them was that they weren't very good at it. The people who would be charged with doing it weren't very good at it, and it would lead to error.
Okay. Now I want to focus on pre-election litigation in the federal court. These titles are confusing because they're all quite similar, but there's a case called Donald Trump for President versus Bookvar, which was decided in the Western District of Pennsylvania in October of 2020. Are you familiar with that case?
Yes, sir.
All right. And first of all, that case discusses something called Pullman abstention. What is Pullman abstention?
Pullman abstention is a doctrine where when the federal courts are deciding a case which involves at some level interpretation of state law, and they believe that the state law is not actually clear and it's important enough, that they encourage the parties to go to state court to get an authoritative interpretation of what state law means. And then the parties can come back to the federal court once that's decided and continue with the litigation.
And had the federal court in this Donald Trump for President versus Bookvar case engaged in Pullman abstention prior to the issuance of this opinion?
Yes, sir.
And tell us about that, if you will.
Well, the federal courts basically said, hold up, these are big, important state law questions. There hasn't been enough litigation in the state courts for us to make a good determination or how the state courts would decide. And of course, their interpretation would be authoritative. So the parties went to court, ultimately to state court, ultimately to the state Supreme Court. And once these issues were decided, they came back to the federal court, and the federal court could decide all the remaining issues.
And when they went to the state Supreme Court, that was in one of the cases that we just discussed a moment ago, correct?
Yes, sir.
All right. Now, did the federal court also issue a ruling about standing in the Donald Trump for President versus Bookvar case?
Yes, its standing ruling was that possible vote dilution wasn't enough to give the Trump campaign standing.
Um, but did the court make an alternative ruling on the merits in addition to its standing ruling?
Yes, sir. It weighed in three different merits claims. It held that guards were not required at drop boxes, and it ultimately agreed, as it should have, with the Pennsylvania Supreme Court that there was no signature comparison required, and that the residency requirements for canvass observers were okay.
Yeah, do you remember the procedure? Well, this came up on a motion for summary judgment, correct?
Yes.
And what was the standard of review that the federal court applied to these state procedures?
It applied the rational basis test,
And
which is a
good. I'm just going to ask you to explain a little bit more what that means.
sure. There are in constitutional review three different so-called tiers of scrutiny. There's reduced scrutiny, intermediate scrutiny, and strict scrutiny. Reduced scrutiny is the weakest of the three, and it generally requires that the procedures that are being challenged in order to survive constitutional scrutiny be rationally related to a legitimate governmental purpose.
All right.
And it gives the state some deference on both the means and the ends part of that, whether something is rationally related and whether the governmental interest is legitimate.
All right, I want to turn now to litigation that arose while the election canvassing was going on. Are you aware in Philadelphia of litigation that began during the canvassing process of the mail-in ballots?
Yes.
And tell us about that litigation, if you will.
Well, there was the Vantage Point litigation, if you will, which challenged the positional requirements of where the canvass observers had to be in relation to the actual canvassers. The claim, the challenge was based on the claim that they were too far away or otherwise in a position where they couldn't actually observe the canvassing as closely as they should have been able to.
And was this, in what court was this litigated? I mean only that by state or federal, not the particular name of it.
Well, it's sort of really, it was sort of pursued in both.
Well, I'm sorry. I'm going to come to the Bachvar litigation in a moment. I mean, so that was a bad question. So let's just focus on the local litigation for a second. What was the litigation in the local court about it?
This was in state court.
Yeah.
And the trial court, which is the Commonwealth Court, decided that this was okay. That there was no problem. The intermediate appellate court decided that there was a problem and thought that held that the observers should, I believe, have been able to get within 6 feet or so of the actual canvassers. And then that was overturned by the Pennsylvania Supreme Court.
And the Pennsylvania Supreme Court case was called In Re Canvassing Observation. Is that right?
Yes, sir.
And tell us what that case held.
That case held that the state statute did not give people, observers, the right to get close enough so that they could note whether the requirements for the outside envelope were actually carried out. And as part of its reasoning, it said that there is no right for, noted that there was no right for the canvassers to actually object to any kind of problems there. And it pointed to the statutory language, which I believe was they had a right to be in the room. And said that under those circumstances, the statute didn't grant the canvass observers the right to the kind of proximity they were requesting.
Now, during the course of this litigation in the state courts, and I think this is where you were going before I interrupted you, was there a compromise in another litigation that was brought in federal court in Philadelphia?
Yes, sir. There was a federal case brought, and there was an informal settlement there, which allowed more than I believe the statutory allowed amount of observers for each party to observe, and allowed much closer proximity than there had been before.
All right, now I want to turn to the Donald Trump for President Inc. v. Bachvar case in the Middle District of Pennsylvania. And first, let's just take an overview of the case, and we'll come back and go through some of the specific issues. Would you show the witness, please, Disciplinary Counsel Exhibit 5?
Is that Judge Braun?
Yes.
Brand, sorry.
So this is all right. So do you know this was the case in front of Judge Bryan? I'm going to lead a little bit because I don't think there's anything controversial about this. Do you know when? Can you determine when it was filed?
November the 9th, 2020.
And the plaintiffs were whom?
The plaintiffs were the Donald J. Trump for President Inc., which was the campaign, and then two individuals, Lawrence Roberts and David John Henry.
And the defendants were whom?
The Pennsylvania Secretary of State, Kathy Boockvar, and then 7 election boards for various counties.
Okay. What is your understanding of Mr. Giuliani's role in this matter?
I'm honestly a little bit uncertain. There was some participation in by Mr. Giuliani in this complaint. Excuse me, I may be confusing this with the first amended complaint, which is coming up earlier. I believe that Mr. Giuliani was responsible for this complaint.
Okay. Now let's look at that first amended complaint, which is Disciplinary Counsel Exhibit 6. Can you determine when that was filed?
November the 15th, 2020.
Was there any change in the parties?
No, sir.
And your understanding of Mr. Giuliani's role in this one?
This is the one where my understanding is a little less certain. In a Colorado deposition, I believe Mr. Giuliani indicated that he was the one who started writing the complaint. But in yesterday's testimony, he indicated that he was responsible for maybe only 10 or 20% of it, some paragraphs, so that his participation was much less.
Okay. Mr. Giuliani did not sign this complaint, correct?
No, sir.
Let's now put up Disciplinary Counsel Exhibit 8, which is the transcript of the oral argument. I take it you've read this document?
Yes, sir.
When was the oral argument conducted?
November the 17th, 2020.
And what was Mr. Giuliani's role in the oral argument?
Mr. Giuliani was primary counsel for the plaintiffs.
And then finally, let's put up Disciplinary Counsel Exhibit 9. And this is the motion, but we've all had plenty of testimony about the second amended complaint. Tell us when that was filed.
It was filed on November the 18th, 2020.
And any change in the parties?
No, sir.
And did Mr. Giuliani sign this complaint?
Yes, sir.
And in addition to this complaint, were there some ancillary pleadings or filings that were filed along with it or a day or so later?
Yes, sir.
And just tell us generally what those were.
Was a request for a temporary restraining order, various forms of adjunctive relief, and I believe a memo supporting them.
Was this complaint and these ancillary proceedings ever, strike that, were this complaint and the ancillary proceedings ever accepted for filing?
No, sir.
All right. We can take that down now. Now, having gone through the overview, let's go back a little bit to some of the claims. First, in the initial complaint. What can you tell us what claims were pled in that initial complaint?
The initial complaint had versions of the complaints that remained in the claims that remained in the First Amendment complaint, which sounded in equal protection and due process, largely aimed at challenging the notice and cure, the application notice and cure process, and then also of the challenges to the vantage point restrictions. But the initial complaint also contained claims that are now went to the independent state legislature theory that said that basically made the argument that state administrators or state executives could not actually issue or make the kind of interpretations of law they had, because that kind of authority belonged only to the state legislature.
I want to just pause on that for a moment because that issue kind of disappears. So tell us what happened to that issue in the case.
That was in the the initial complaint, dropped from the first amended complaint, appears again in several counts in the second amended complaint. It did not appear much in the oral argument at all because it was not in the first amended complaint. Then when the plaintiffs appealed the loss before the district court, before the Third Circuit, the Third Circuit said that they did not have standing to raise, just in passing, said they didn't have standing to raise those claims because of a prior Third Circuit decision called, I believe, they may get mess up the pronunciation, either Bognet or Bognay.
Okay. All right, I'm going to largely ignore the, you call it the independent state legislature, sometimes called the electors and election clause claims.
Yes, sir.
Okay. To go back to the initial complaint, what, if anything, did the initial complaint say about fraud?
The initial complaint was clear that there was fraud, although it was a little bit less clear actually what the fraud consisted of. It appeared to most directly allege that there had been intentional misdealings and perhaps concerted activity between various election boards, and certainly within election boards, to wrongfully deny candidate Trump votes.
Now, can you just go into federal court and file a case challenging a state election, claiming that there was election fraud, or do you have to allege more than that?
In any case involving fraud, Federal Rule of Civil Procedure 9 requires that all the elements except for state of mind be pled with particularity, which means certain amount of specificity beyond the normal complaint requirements, bearing on the circumstances around the fraud.
And does election fraud in a state election raise a federal claim in and of itself?
The type of claim it raises is a due process claim of the Marks versus Stinson type, where if you can show very bad behavior, if you will, particularly if you can show that the candidate collaborated or conspired in it, that can establish a constitutional violation.
So is it fair to say that that election fraud has to amount to a substantive due process violation before it raises a federal claim?
Yes, sir.
Okay. Now, to go to the First Amendment complaint, just tell us briefly how the claims changed in that complaint.
But I'm sorry, I didn't hear.
My apology. In the First Amendment complaint, how did the claims that were pled change?
The First Amendment complaint pretty much dropped out the grand fraud claims, but continued to press the vantage point observational boundary claim and the notice and cure claim.
And then to come to the Second Amendment complaint, how did the claims change in that complaint?
The fraud claims came back in.
All right. And with respect to the question of intentionality of the state authorities, how, if in any way, did that change in the Second Amendment complaint?
Well, the Second Amended complaint alleged intentional, basically an intentional conspiracy among various local officials. It was clear that I believe alleged it within election boards, but it's not clear whether it alleged it across election boards or not. Yesterday, Mr. Giuliani testified that, in fact, this was he was interested in his oral argument before the district court in keeping open the possibility that there was a interstate fraud conspiracy. But that did not appear in the First Amendment amended complaint, and indeed the Second Amended complaint seemed to be limited to fraud within election boards.
And let me call your attention to the Disciplinary Council Exhibit 9, and I want to look at the first part, which is the motion for leave to file, and page 8 of that document. And if you can blow up the paragraph 20, just on page 8. Well, that's fine, right? Just on page 8.
Right.
You'll see there it says the plaintiffs will also show that defendant's conduct was part of an improper scheme to favor Biden over Trump by counting improper votes in violation of equal protection, due process, and electors and election clauses under the Constitution and Civil Rights Act. Had the first complaint been as explicit with respect to this intentionality element?
Do you mean the First Amended complaint?
No, the first complaint.
The first complaint.
Yeah.
No, the first complaint was not so clear.
Okay. Now, I want to come to the relief that was sought, but since we're at a particular appropriate point, let's continue with this document on that issue, and let's go down. Let's stay right where we were. But I want on that's right. The bottom sentence, the last sentence of 20 and going on to 21. You'll see here it says that the plaintiffs will seek the remedy of Trump being declared the winner of the legal votes cast in Pennsylvania in the 2020 general election, and thus the recipient of Pennsylvania's electors. Had any federal, aside from Marks v. Stimson, are you aware of any federal court that had ever provided such relief?
No, sir.
And okay, that's all the question I have. So now let's go to the actual Second Amendment complaint. And I want to look at the relief that was requested in the complaint itself. go to, please, to page 122, paragraph 325. You'll see here where the well, why don't you just read to us what the relief that's asked for in this paragraph is?
That as a result of defendants' violations of the United States Constitution and violations of other federal and state election laws, this court should enter an order, declaration, and/or injunction that prohibits defendants from certifying the results of the 2020 presidential general election in Pennsylvania on a statewide basis.
Are you aware of any other case where that relief, the prohibiting the defendant from certifying the results of the election, has been provided?
No, sir.
Let's look at the next, let's look at, sorry, paragraph 326. And just read to us the relief that's requested there.
Ultimately, that as a result of defendants' violations of the United States Constitution and violations of other federal and state election laws, this court should enter an order, declaration, and/or injunction prohibiting defendants from certifying the results of the general elections, which include the tabulation of unauthorized votes, including mail ballots which did not meet the statutory requirements, mail ballots which were cured without authorization, and any other vote cast in violation of law. Instead, compel defendants to certify the results of the election based solely on the legal votes.
In an election involving secret ballots, I'm sorry, is somebody saying something?
No,
I heard something. I don't know if there's an objection or.
No, no objection.
Okay, I'm sorry. In an election involving secret ballots, after they are cast, is there any way to determine which ballots don't meet the statutory requirements or were cured or otherwise cast in violation of the law?
Only if they were segregated in the appropriate categories.
And so if they weren't segregated, how could a court impose this remedy?
It's difficult to imagine how you would be able to tell which were the ballots in one, which were legal and which weren't after they've all been mixed together.
Okay. Let's look at paragraph 327. And it reads as the relief that's requested there.
Alternatively, that as a result of defendants' violations of the United States Constitution and violations of other federal and state election laws, this court should enter an order, declaration, and/or injunction that the results of the 2020 presidential election are defective in providing for the Pennsylvania General Assembly to choose Pennsylvania's electors.
Again, has any court ever imposed such a remedy in any election in the United States of America?
No, sir.
What would be the authority of the Pennsylvania General Assembly to choose Pennsylvania's electors if somehow there was a problem with the election?
The claim would be that its authority under Article 2 to choose the method of the electors somehow allowed it to make this kind of decision even after a general election.
So to be a little more specific, Article 2 gives the legislature some authority as to how electors are going to be chosen, correct?
Yes, sir.
Does Article 2 require the Pennsylvania or any other state to pick the presidential electors by an open election?
No, sir. In fact, for much of the time of the country's founding, some states chose the legislatures would choose the electors themselves.
But once a state adopts a law saying that they're going to be chosen by federal electors, can the legislature just decide the issue anyway?
That's under that type of issue is very unclear. And it's up, this may be part of the implications of the case that's being argued in the Supreme Court tomorrow, in fact. But there hasn't ever been a case where a court has issued that kind of relief.
Now, yesterday, and I think again today, Mr. Giuliani testified about the relief that he was seeking with specific respect to the equal protection arguments on behalf of the two voters whom he represented. You recall him testifying about that?
Yes, sir.
Did you understand the relief that he said he was seeking?
Not really.
Okay. And do you see a prayer or a request for relief at any place in that resembled whatever that request was, in any place in these three complaints that he filed?
No, sir.
And did he allude to it in his oral argument in front of Judge Brand?
No, sir.
Okay. So let's go to the oral argument in front of Judge Brand. What did Mr. Giuliani argue as a factual basis for his claims before Judge Brand? Let me, before I get to that, what was the position that Mr. Giuliani took before Judge Brand as to whether he was arguing fraud?
He initially said that he was arguing fraud. And then when Justice Brand stated that fraud claims are subject to the heightened specificity requirements of Federal Rule of Civil Procedure 9, he backed off that and said that he wasn't he's making allegations about what happened and what the procedures are and some of the problems with him, but he wasn't characterizing them as fraud.
Okay. And at that time, which one of the three complaints was the one that Judge Brand was considering?
The first amended complaint.
And that's the one that didn't have any fraud allegations, right?
Yes, sir.
Okay. And so what arguments did Mr. Giuliani advance to establish that there was fraud in the 2020 presidential election in Pennsylvania?
He made several different kinds of arguments. I start discussing these in my report in paragraph 20.
Do you want to refer to that, or?
I would be happy to refer to it if I may, just because that way I would be able to do better than just stumbling through it.
Sure. Is there any objection to that?
Okay. No objection.
Okay. Go ahead then. We don't need to put it up. We don't need to put the report up. He just wants to refer to it as testimony. All right.
Yeah.
So tell us the arguments that he made.
So he relied on several different types of allegations to make his case. They fell into various different categories. The first was that statements by various authorities about the potential for mail-in ballot fraud, evidence fraud in the 2020 Pennsylvania election. Secondly, that misconduct in jurisdictions outside Pennsylvania during prior elections and during the 2020 election itself, somehow evidence fraud in the defendant counties in the defendant Pennsylvania counties in the 2020 election. Third, that apparent misconduct in some Pennsylvania jurisdictions during prior elections was evidence of fraud in the defendant counties in the 2020 election. Fourth, the alleged election administration irregularities in 3 non-defendant Pennsylvania jurisdictions were evidence of fraud in the defendant counties in that election. Fifth, that observational boundaries imposed generally on all candidates and party representatives during the canvassing process was evidence of fraud in the defendant counties in the 2020 election. And sixth, that certain statistical studies or figures related to the mail-in ballots were evidence of fraud in the defendant counties in that election. And 7, that additional proof that was referenced generally by the district court was evidence of fraud in the elections. I take it that that's what he was referring to in the 240 or so affidavits that he mentioned this morning.
Now, with respect to the first 4 of those categories, the potential for fraud in mail-in ballots, historical fraud in other jurisdictions, historical examples of fraud in Pennsylvania, and fraud in other counties in Pennsylvania. Was any of that evidence of fraud in the 7 counties that he sued?
No, sir.
And with respect to the last 3, were the observational boundaries evidence of fraud?
No, sir.
And what I'm sorry, I've gotten lost in the other 2. This was the statistical. Did he provide what statistical evidence he had?
He provided there was the evidence changed at various times. So, for example, he introduced statistical evidence in the before the Pennsylvania state legislative hearing by a colonel, I believe it was Colonel Waldron. He also introduced some evidence by Mr. McCready, I believe his name is Mr. McCready's, at some point, about, which was quasi statistical, about the difficulty of how it would have been impossible to actually count the ballots with the speed that they were reported as being counted statewide in the 2020 election.
And were either of those gentlemen, did either of those gentlemen disclose that they had any expertise in this area?
No, sir.
What was Colonel Waldron's background?
Let me see here. That appears in paragraph 34 of my report. So Mr. Waldron has never made public, as far as I've been able to see, the basis for his statistics, which is based on so-called statistical spikes and so it's simply not been able to be tested. As for his expert qualifications, as he acknowledged directly to Mr. Giuliani during the state legislative hearing, he wasn't, quote, he was, quote, not a statistician, and he didn't do well in math. He also describes himself on his LinkedIn page, as of the time I did the report, quote, as the founder, forklift driver, and floor sweeper at One Shot Distillery and Brewery in Dripping Springs, Texas. And he lists no election administration in his work history.
Yeah. And what about with respect to Mr. McCready's? Do you recall what his qualifications were? Actually, it wasn't his analysis. What did Mr. McCready base his statistics on?
Mr. McCready's based his claim that the ballots could not have been canvassed as quickly as they were on a remark by a former Mercer County, Pennsylvania election administrator, that on the basis of that administrator's past experience, it would have taken his county, it took his county 2.5 days to process 655 provisional ballots, and I believe the primary election in 2020. And it then extrapolates from that to impute a statewide maximum processing speed from that one jurisdiction's ability to handle canvassing in that one election.
Now, you mentioned that these experts were presented to the Pennsylvania legislative hearing. That's something that occurred in Gettysburg some weeks later, correct?
Yes, sir.
With respect to the argument before Judge Brand, did he present any statistical evidence at all at that point?
I don't believe so.
And then the other thing we said was the affidavits, which I think we've all discussed.
Yes.
Now, I want to talk about what constitutional violations that he alleged. What were the constitutional violations that he alleged to Judge Brand with respect to notice and cure?
The notice and cure claim was based on the notion that allowing voters in the 7 defendant counties to cure the deficiencies in their mail-in ballots diluted the vote of the 2 voters in the 2 other counties which didn't permit cure.
And did he also have an equal protection argument with respect to notice and cure in which he somehow relied on Bush v. Gore?
Yes, sir. In that he claimed that it was a violation of Bush versus Gore because different election boards were administering the rule differently.
And what did Bush v. Gore have to say about different localities having different procedures?
That it wasn't making a holding on that.
Okay. And you also read us a language earlier in which it acknowledged that those things occurred, correct?
Correct.
All right. Now, with respect to observational boundaries, what was Mr. Giuliani's constitutional argument about those?
The constitutional argument that appeared in the complaint, First Amendment complaint, was that by imposing these positional boundaries, the election boards were making it more even-handedly on Republican and Democratic observers. The election boards were, in fact, making it more difficult for Republican observers to challenge absentee ballots that are being administered in Democratic majority jurisdictions.
And what constitutional violation was that?
That was mostly equal protection, but also substantive due process. They were somewhat run together in different complaints.
What, if any, evidence did Mr. Giuliani present that the Biden observers have been treated differently from the Trump observers?
In the oral argument and the First Amendment complaint, basically none.
Yeah.
And the court, both the district court and the Court of Appeals found that.
Found
That there was no,
yeah, okay,
that they're treated even-handedly.
right, okay. No, your voice dropped off a little.
Oh, I'm sorry.
And what, if any, evidence did he present of improper vote counting in the before Judge Brand?
None.
And how did Judge Brand in the district court resolve these issues?
Judge Brand held that the Democratic observers and the Republican observers were basically treated even-handedly, and so there is no violation.
And what did he find with respect to that's the equal protection. What about with the argument about substantive process and the observational boundaries? What did Judge Brand find about that?
Well, the substantive due process argument in the first complaint, Judge Brand considered to be the overall or overarching fraud claims. And he thought that Mr. Giuliani had withdrawn them.
Now, was Judge Brand's opinion appealed to the Third Circuit?
Yes, sir.
And what actually was the issue that was appealed to the Third Circuit?
The actual issue appealed to the Third Circuit was whether Justice Brand had erred by not allowing the filing of the second amended complaint.
And can we put up disciplinary counsel exhibit 16, please? And you recognize this is the Third Circuit opinion?
Yes, sir.
All right, I want to refer to you to three specific.
Mr. Fox, before you continue, how much more do you have with this witness?
You know, if I would say that I have, after this Third Circuit, I'm going to ask him a little bit about the provisions of Rule 11. Then I'm asking for his opinions. I could probably, it's 5. I mean, I'm sure I can wrap it up by 5:30, but if you want.
Yeah, he's gonna have to continue tomorrow in any event, so I think this might be an appropriate time to break for the day.
Okay.
Anything else we need to discuss before we recess?
I'm ready. Yes.
Again, Mr. Fox, this is,
Mr. Chair, just wanted to sketch as far as tomorrow's schedule. We want to plan for our witnesses. We should have them available for, I'm not sure time wise, if we should plan for the afternoon or.
I would know, I think that, how much time do you have, Mr. Fox, on?
I'm going to finish with Mr. Ortiz in 15 to 30 minutes.
Oh, okay. All right. So we'll plan then for the sometime in the morning.
You'll advise Mr. Fox who you're calling.
He knows.
No, we've given him a list of,
No, but I don't know which ones in which order as the chair ordered at the outset.
well,
We'll have to
You
call.
can do that, when we, off the record, but I want you to tell him who you're gonna call and in what order tomorrow, so he.
yes, we will do that.
We'll do this in a civilized fashion.
Well, everything is
Any-
civil.
Anything else we need to discuss? Okay, thanks. We're adjourned for the day. See you at 9 a.m. tomorrow.
Thank you.